I started this petition by simply filing a petition to modify child support. Then he has, through his counsel, Ms. Hendrickson has filed a petition to modify the parenting plan. From a logistics standpoint, my petition to modify child support is going to be factored into the modification of
Obviously, I need to hear the
custody.
petition to modify the parenting plan to determine how many days each one of them has to determine the child support.
So and after that, I filed the petition for contempt. So it just seemed, counsel and I were talking, Ms. Hendrickson and I were talking about the fact that it seems just putting my client up and saying this is your income and then calling her back down and me calling him on the petition seems a little bit far-fetched in the fact that he should move on his petition because mine is encompassed in
Right.
the request for modification,
Well,
if the
then
courts
it seems
agree.
to me we hear the petition to modify the parenting plan first, and then we'll deal with the child support issue. So, Ms. Hendrickson, does either side wish to make an opening statement?
Good morning, Judge.
Good morning.
In this matter, I represent the father, Mr. Jones. As was mentioned earlier, this started in a petition to modify the child support, and we did file in an answer to that in a counter petition to modify just only the residential schedule. So we're not asking to modify the designation of the permanent primary residential parent, nor the decision-making. And I did file, just I believe yesterday, a revised proposed parenting plan because there was an error in our first proposed parenting plan. We did not mean to request to change the decision-making of the parties. And so I would just like to begin, Judge, by saying that the parties here is in no way similar to the first parties. The parties are actually—
What you're saying is that the situation here is not like the last one?
There's no animosity much in the parties here. I actually commend the parties because they really work together, just looking at their text messaging, that's how they communicate primarily. There are some instances, very isolated instances, where my client had sent a not so good message to the parent, Mrs. Maples, but those are isolated, and I would say or submit to the court that within the past year or within even this year, they have been managing their co-parenting really well, to the point of even through the litigation, they have managed to agree on the Memorial Day weekend residential schedule and things of that nature. And so what we're want to bring to the court's attention is that there has been a material change in circumstances for the purpose of changing the residential schedule. Just among other things, majorly, my client is now working only 4 days a week instead of the 5 days a week. So that enabled him to spend more time, and he had made a conscious decision in the past 2 years to spend more time with the child. The child is now going to school. The past 2 years, he was about 2 years old when the parenting plan was established in 2017. So he started school, finished two years now. So his developmental needs have changed over time. Both parties are now married. Their respective spouses are very supportive of their co-parenting, which is great. Mrs. Maples have a child with Mr. Maples. My client's wife, Kirsten, is with child. She's expecting in a couple of months here. And you will hear from her hopefully today to testify. Mrs. Jones has an 11-year-old son. He is very close to the minor child that is the subject of this matter. And the minor child right now is 7 years old, I believe. His name is Fred. And also, we would submit that the parties, some 2 years ago, back in June or July of 2023, agreed. The conversation was initiated by my client. He requested for more time. And in fact, he was represented by Ms. Smith, and they were trying to do mediation, but just didn't come to fruition. But however, via text, the parties talked about it, and Mrs. Maples, out of the abundance of her kindness, offered Thursday to Tuesday. So instead of the original Friday to Sunday, which is 2 nights every other week, my client has been getting the child Thursday to Tuesday every other week, 5 days. In the original parenting plan, the father also may get the child Mondays and Tuesdays after school and return to Mrs. Maples when she gets out at 7:30 p.m. That is not the case anymore. And even in Ms. Maples' words in her text, that doesn't work. And I believe that she also has a different work schedule. I believe she works for the school now. So her schedule is Monday to Friday, and she gets out earlier than 7:30. So that's not workable anymore. So, Judge, because it's a request for a modification of residential schedule, as you know, it's a lower thresholds, but preponderance of the evidence. The case Amberster versus Amberster, the Supreme Court case, which I'm sure you are aware of that case, did provide the trial courts with the analysis of how you go about determining whether there's a material change in circumstances, and it would include if it affects the welfare of the child, foreseeable circumstances such as going to school, getting older, having different developmental needs. And so in this case, we submit that all of these changes does affect Rhett's welfare in a meaningful way. And, and as it relates to the change in or modification of the child support, it would be inequitable for my client to continue, and Mrs. Maples is agreeable to continue the Thursday to Tuesday, but my client not have credit for that in the child support worksheet. And he has been providing financially when he has the child. So Mrs. Maples is not giving him, and rightfully so, because Mr. Jones, my client, is amenable to providing for his son. And he's gone above, over and beyond what the child support order was. He's been providing for extra needs for this child, and that will be shown in the proof. Thank you, Judge.
Ms. Roberts?
Your Honor, again, if my client changed jobs, he changed jobs. She had a afterborn child. He now is expecting an afterborn child. So originally, we filed just to modify the child support. If I could, Your Honor, back on May 7th of 2020, the existing parenting plan was filed with this court. Both parties were represented at the time, and of course, Ms. Willie was designated as the primary residential parent. The father was afforded residential time with the child every other weekend from Friday at 6 until Sunday at 6. And additionally, he could pick up the child from daycare on Monday and Tuesday and keep the child till 7:30 because my client's work schedule was such that she worked on those days and he was able to pick the child up at daycare. The parties, again, mutually agreed that he could have the child from Thursday afternoon until Tuesday because it just merged that schedule together. His work schedule changed, her work schedule changed. That is what the child is used to, that's what the child has done, and that's our proposal as far as adapting to this child. There is no basis just to go and just do a 50-50 just because he wants it.
You're agreeable to keeping the Thursday through Tuesday?
Yes, Your Honor, every other weekend. So he has the child 10 days.
He has it 5 days in a row, 10 days out of the month.
Yes, sir. And that's what the parties have been doing. They both stipulated and agreed to that without the necessity of a court order.
Which I think is commendable.
To extend the father's time so he can have blocks of time with the child. This is consistent with his work schedule and consistent. The child is now in school going to Van Leer. That's where my client resides. She works at the school system. And she works at Burns, but the child has started school there, and his friends and his associations are there. And again, we have no problem in adapting what was established by the court, or not what was established by the court, but what the parties agreed to as was in their child's best interest. And then just to come up and say, hey, because we agreed to just encapsulate the time instead of doing a Monday and Tuesday where you just get from after school, spend the night with it. That's just not a basis to come up and say, because you agreed to a modification, now we want more. The consistency of the child in school, the both families that the child experiences with, the consistency that the child has had, and that this schedule has worked. And that's where we think that the court should just adopt that schedule, take the party's income. And again, so what we're going to be doing is, we filed this petition, so you've got a modification from the date that we filed. My client then, in August, after she filed the petition, in August, she had her afterborn child, so the modification from the date of the filing until her afterborn child was born, then she has a credit for an afterborn child, and that will be the number of days based on what he has now, up and until time when he has an afterborn child, which I think is in I was inquiring, but I think his child is due in July. Is that correct? So in July, there would be a further modification whenever that child comes into effect. Then, Your Honor, we do have an issue of a contempt that we filed because the father, during his residential time, had the child baptized, and they're supposed to make joint decisions with the mother having it. Religion is one of the factors, and the court, I'm sure, is well aware of the factors that, and the court decisions that have been set down, especially on baptism, when it's supposed to be a joint decision-making, and he did not include the mother in that.
All right, well, we're shortly before noon, so we'll take our noon recess now, and we'll attempt to resume shortly after 1 o'clock. One thing, I'm happy to hear that the parties have been working together so well in the past. And unfortunately, sometimes these kinds of cases, the litigation and the actual trial can create more animosity and can destroy the cooperation that has existed up to this point. So hopefully that will not happen, but we'll give you an opportunity to present whatever proof you want when we resume. We'll shoot for 1 o'clock.
Thank you, Your Honor.
Mr. Jones, state your name for the record, please.
Gregory Kyle Jones.
Okay. And you have a minor child with Mrs. Maples.
I do.
And what is his name?
William Rhett Jones.
How old is he?
He's 7.
7 years old. And your current parenting plan, that was established in May 7 of 2020, correct?
Yes, ma'am.
And he was what, 2 years old at the time?
2.5.
2.5 years old, okay. And what was your marital status at the time the parenting plan was established?
I was not married at the time.
Okay, and neither was Mrs. Maples now, correct? She was not married at the time? too?
Correct.
Okay. And since then, have you been married?
Yes, ma'am.
And you're married to Miss Kristen Jones, correct?
Yes, ma'am.
And she's with child right now? Is that correct?
Absolutely, yes, ma'am.
And when is her due date?
The end of July.
End of July, okay. Do you know what is it a girl or a boy, or is that a
It'll
secret?
be a little girl.
A little girl, okay. Okay, and then so Mrs. Maples has since been married too, is that right?
Yes,
Okay, and she has a baby
correct.
with Mr. Maples, is that
Right.
correct? Do you
Yes,
know
ma'am.
how old her child
I'm
is?
not.
You don't
I
know?
don't know for sure.
Okay. All right, so who currently reside in your household?
So you just have myself, my wife Kristen, my stepson Noah. He's actually 12 now.
Okay.
And then Rhett is with us the 5 days.
Okay, so your wife Kristen has her son Noah, and Noah's how old now again?
12.
12 years old. And what is Kristen's residential schedule with Noah?
We have him all week. He goes to his dad's every other weekend, Friday
Every
and
other
Sunday.
weekend. Okay.
And then there's a lot of exceptions where they work it out and he goes to spend extra time with his dad.
Okay. All right. And so where were you employed at the time the parenting plan was established?
I'm wanting to say I was at Material Handling Inc.
Okay. And what was your schedule at the time?
I was working 5 days a week,
Okay.
typically 7 to 4.
Okay. And did that change at some point?
Yes.
Okay. And so what did it change to?
So then I had swapped to Toyota Material Handling Inc. And then in the spring of 2022, they adopted the 4 days. We work 4 10s, and then
Okay.
it's a rotating day. So let's just say this week I'm off Monday, the next week I'm off Tuesday. and
Okay.
It just keeps going.
Okay. And from what time to what time is your shift there?
It's pretty flexible. It's whenever you start, that's when you start your 10 hours.
Okay. Like for example, the other day, did you work yesterday? or
Most
the
of the
other
time
day?
I'm working 6 to 4:30.
6 to
That's
4:30.
typical.
That's your typical
Yes,
time.
ma'am.
Okay. And how many hours a week do you typically put in?
40. I mean, I don't get a lot of overtime. I
Okay.
have gotten some overtime here recently because I've been doing some extra training just to try to further my education in what I'm doing.
Okay. And we provided Ms. Roberts with your income information. So I'm gonna go ahead and show you this.
Thank you.
You can tell me what those are?
Yeah, this is last year's W-2 and then a statement for May 2nd, which would be a 2-week pay stub.
2-week period of this year, correct?
Yes, ma'am.
Okay, so for your W-2 2024, does it state that your gross income, and I'm looking at with the Social Security wages, it was $61,091.49?
Yes, ma'am.
Okay, 61,000, yes. Okay. And then for your pay stub for May, that was a pay date of May 2, this is a 2-week period?
Yes.
Okay. And your hourly rate, it states 39.95? Is that right?
No, regular is 33.
I'm sorry, 33.95.
Yes, ma'am.
Yeah, I misread that. And in this pay period, you put in about 77 hours plus 1 hour of overtime,
Yes.
correct? Okay. And so your gross income on this is $2,962
Yes.
dollars
Yes,
and
ma'am.
14 cents.
Yes.
Your Honor, I would like to enter that as an exhibit.
Mark it as Exhibit 1.
For the May pay stub, $2,962.14. Gross pay on the left side. Okay. So, Mr. Jones, in your current parenting plan, tell us how many days Mrs. Maples was assigned, and then how many days for you?
I'd have to do the math, but specifically in the parenting plan, it states that I get my son every other weekend
Okay.
from Friday to Sunday.
So that's 275 days for her and 90 days for you.
Right.
Sound right? Okay.
Right.
So you get under that parenting plan every other weekend, Friday to Sunday, correct?
Correct.
Okay. And then there's a stipulation there that Monday and Tuesday you may also get him after school, and then return to Mrs. Maples at 7:30 p.m. Is that correct?
That would have been the current.
In the
yes.
current,
Yes,
okay.
ma'am.
And so, what is the current schedule now?
So since July of 23, we have right before he established school, I initiated a conversation about going ahead and seeing about getting my son more And she agreed that we would do every other Thursday to the following Tuesday. So I pick him up from school Thursday, I take him to school, pick him up Friday, have the weekend, take him to school, pick him up Monday, and then take him to school Tuesday, to which she picks him up from school.
And so, so you have been doing that for about 2 years now, is
Yes,
that
ma'am.
right?
Yes, ma'am.
And how has that affected Brett? Has he adjusted to
Oh,
that
he
schedule?
adjusted very well. He knows when I'm picking him up. He knows when he's going to his mother's. I mean, he's done very well.
And so because you testify that your work schedule has changed, how does that affect the time that you spend with Brett?
So in the summer, the days that I do have off that I have him is great because we just get that whole day together. And then usually me and him and Rhett, or me and him and Noah are usually going and doing some kind of outdoor activity of some sort. So it's been
What
great.
about during the school time? Are you able to spend more time with him?
Yeah, I get to take him to school and then pick him up, and he loves it when I'm the first one in line. So when I'm off, I can be the first one in line.
Okay.
And then we just have that whole evening to spend together.
And so right now, I mean, it appears that Mrs. Maples is agreeable to the Thursday to Tuesday.
Right.
But we're asking if the court will allow you to have a 50-50 type situation where it's a
Yes, ma'am.
Sunday to Sunday or Friday to Friday,
Yes, ma'am.
whichever. So, would your schedule allow for that?
Absolutely.
Okay. And do you have the willingness to take on more parenting responsibilities if given the opportunity?
More than willing. Yes, ma'am.
Tell the court, Rhett has, he's 6 years old now, so has he gotten into different types of activities that he's able to do with you?
Yes, ma'am. And he's 7 again. But
7 years
yeah.
old, I'm sorry. He was 6 during this.
Yes.
Yeah.
He recently got into soccer. So when he was with me, I don't know anything about soccer, but I definitely tried to learn some stuff, just to be able to spend time with him. I make all the soccer games, as many practices as I can. Baseball, I coached his baseball team multiple years. I mean, we just do everything. He's right here with me all the time. Like, we're always together.
Okay. In terms of the day-to-day needs for Rhett, tell the court what is your participation in that during your parenting time?
I just make sure that he's got everything he needs. We play, make sure he's eating good. Anytime he's eating something new, I always send that to his mother because we just try to make sure that he's eating healthier.
Okay.
And he's really picky, so when he eats something new, we make sure to let each other know.
All right. Speaking of your communication with Mrs. Maples, describe how is the communication between you and Mrs. Maples progress? It's been 5 years now since
Yes, ma'am.
that parenting plan was established.
I mean, sometimes it can be a little tricky, but I mean, for the most part, it's really good. Usually, if I need him for a day that I have something planned that I know he would like to be a part of, I communicate that to her, and she'll usually accommodate that, and we'll swap some days around, or vice versa. It's for the most part, it's really good, and then up until now, I mean, it's been really good in the past few years. So
Okay. Had there been communications where there was some conflict between the two of you?
yes, ma'am.
Okay. So I'm going to show you. Can you, do you recognize that text messaging?
Yes, ma'am.
And who are in that text messaging? Between,
So this was when she decided to move right to the different ballpark. This would be me and her texting back and forth.
so it's between you and Mrs. Maples?
Yes.
Do you remember when this was?
This was last spring.
Last spring of 2024? Okay. And so just give us an idea of what, what's going on with this text messaging.
So Rhett had decided to play t-ball first year, and I had been coaching for numerous years at Buckner Park in Dixon. I was going to coach him again, and just as before, and it just all of a sudden he signed up in Charlotte, and this was I was asked to be a coach, so in that usually you get your own child as the coach.
Okay.
But another guy was there and said that he was keeping him, and then it just kind of got into an argument because Aaron, which was the other coach, told me that he would have to check with the mother. Oh,
Well, I don't know if it's actual hearsay unless it's being introduced to prove the truth of the matter. What's the purpose of introducing a statement?
Just to explain why he sent a message that's, it's not very savory, but we're trying to give a background of the text message that my client sent.
Avoid quoting. You can't quote what somebody else says. You can explain why you did a certain thing. I am of the opinion that, at least I don't know whether it's actual hearsay, unless the purpose for which it's introduced, but I'll sustain the objection at the moment.
Let me ask you a different question.
Sure.
So would you agree that this text message that you sent Mrs. Maples, was that an appropriate text that you sent to her?
No, I mean, it wasn't very tasteful, but I mean, I've learned from then, and I'm doing a lot better now. I mean,
And to be clear, this was sent to her in the spring of 2024, is that right?
yes.
And you basically told her here, I'll just rephrase, Judge.
Sustained.
Okay, so after this text message that you sent, was there any other messages that you sent to her that's, a little unsavory or, just using language that should not have been used?
Yes.
Okay. Judge, I would like to enter that as an exhibit. Okay, so do you recognize that text messaging?
Yes, ma'am.
And who are the participants in that text messaging?
Me and Miss Maples.
Okay, and then so this text messaging, can you explain what's going on in this text messaging?
Yes, ma'am. I actually help a friend of mine. We manage some property that he owns. I happened to be out there that day. It's about 5 minutes from the school. His wife was going to pick up their children from the school, and I was just asking Miss Maples if I could have Kimmy pick my son up from school. It was my day to have him, and just bring him to where I was.
Okay, who is Kimi?
That is my friend Justin. It's his wife.
Okay, and you didn't give me a date on this. When did this text occur?
It would have been last year.
Okay,
He
was
was in
it
kindergarten.
around the springtime, I think?
Yeah.
Around May of
Yeah, because we were
2024?
planting crops. What we were
Okay.
doing.
All right, and then, so you had a little bit of a back and forth between you and Mrs. Maples, is that right?
Yes, ma'am.
Okay. As far as you know, have there been any other text messaging between you and her, aside from these two here regarding the coaching and the pickup situation,
The only thing that comes to mind for me is the issue with the baptism.
the baptism? Judge, I would like to enter that as an exhibit. Let me ask you this, those two text messaging that we entered, does that in any way show how your communication had been in the past 5 years?
Yeah, I mean, like I said, it was a little bumpy, but it's very few instances.
Okay, so it does not portray the overall
No,
characterization of your communication.
No.
Well, how would you describe your communication?
I would say our communication is, I mean, if you had to put it in a percentage, 98% great and 2% need to work on.
All right, you mentioned the baptism, so let's talk about that. When was your son, when was he baptized?
I don't even remember that date right off the top of my head.
Was it last year,
Yes,
back in August?
yes.
Does that make, okay. So tell the court, was that a pre-planned event
No,
for your
ma'am.
son?
No.
Okay. Were there any conversations that were had before then?
So we had been talking about filling up the baptism pool. And it was just an overheard conversation between my in-laws, which are the pastors at the church. And then Rhett just overheard it and asked me that night, hey, what does being baptized mean? The boy just believes in God. That was the only thing that we knew, was that they might be doing some baptisms.
Okay. So that conversation, was there anything about you having knowledge that your son was going to get baptized the
Not at all.
following day?
Not at all.
Okay. So then let's go to the following day, Sunday.
Right.
You all went to church, and who was with you?
So my wife was with me, my stepson Noah, and Rhett.
Okay. And then, so tell the court what happened then.
So we just had a regular service, and then all of a sudden, it was just an altar call to anybody that wanted to be baptized. They could come on down and be baptized. Noah decided he wanted to do it, and then Rhett looked up at me and said, "Daddy, can I be baptized today?" And I said, "Son, that's between you and God. It's not between me. It's and you." And that was it. He just went with them. I didn't get baptized that day. My wife didn't get baptized that day. That was just it. That's what
Okay.
happened.
Well, had you known that was going to happen, who would you have invited?
Had I known, my
Yeah.
mother, just like she's here today,
And who else?
I would have invited her. I would have at least let her know that our church doors are open.
Okay. And there was a text message that was, okay, so you testified that had you known, you would have told the mother about this.
Right.
Sustained.
Do you recognize that text messaging?
Yes, ma'am.
Okay. So, who sent it looks like a video in there. Who sent that?
Right. So that was all the time I had to do. I took a video of it so that she could at least see it.
Okay. And explain to the court, so you texted, will you read your message to Mrs. Maples there?
Our boy decided to accept Jesus as his Lord and Savior today. Just wanted you to know. We talked about it last night, and he wanted to get baptized.
Okay. What did you mean when you said we talked about it last night
That
and he
was-
wanted to get
Right.
baptized?
That was me explaining to him what baptizing meant.
Okay.
Then and he wanted to get baptized was meant as he wanted to get baptized. Like, he just sporadically asked me that day if he could be baptized.
On what day?
The day of that Sunday, the day of the altar call.
Okay. And then, so read the next messages there.
So she says that she would have loved an invite to that. And I said, well, I didn't know, so that's my fault. I figured y'all had a church.
Okay. So what did you mean by that when you said, I figured you all had a church?
That if she wanted him to be baptized at her church, I had no problem with that.
Okay. Was there ever any discussion about baptism in the last 5 years since the parenting plan was established?
Not at all.
Okay. And as far as you know, was Mrs. Maples objectionable to your son being baptized?
No.
Okay. And can you read the last message there from her?
Oh,
Oh, it was, this is yours. Yeah, can you read that?
so where she responded? Or
Yes.
we do, but that is something that is a milestone in his life, and I would have come from my buddy.
And then read the next message.
So all I have is the cutoff where it says, I did my best, and I'm pretty sure it says I took a good video.
Just a minute. I'll get back to that. So then, just to recap that situation with the baptism, did you have any knowledge that your son was going to get baptized before it happened?
None.
Tell me about Kristen, your wife, her relationship with Rhett.
She treats him just like if he were hers. I mean, she shows up to everything. As long as, our other son doesn't have something going on, she'll, we have to split then because one has to take one. But she's always looking out for his best interests. She helps with schoolwork. She helps with any special assignments. If she needs to grab something on the way for him, she gets it. We go out of the way, or she will specifically go out of the way to make him something for dinner if we know that he won't eat it.
Okay. And does she help with, day-to-day needs such as picking up Rhett and things of
Yeah,
that nature?
she's absolutely anytime.
Okay. What is the relationship between her son Noah and Rhett?
Oh, they're best buddies. They just run around all the time playing, just as two brothers would do. I mean,
Okay.
he tells everybody, "That's my brother." They love each other.
Now, Mrs. Maples is married to Jacob Maples, is that correct?
Yes, ma'am.
And how is your relationship with Jacob?
It's great. I mean, I think very highly of Jacob. I don't think we've had any disputes of anything. I even went out of the way and made sure that my son called him for Father's Day. I mean, that says a lot, I think. So I do like Jacob, and it's been really good as far as communication up until this point.
Okay. And so just to talk about, again, I'm sorry, I'm skipping here, on the communication situation. So aside from those two text messages that we have entered earlier where there's some conflict, were there communications between you and Mrs. Maples where there's cooperation?
More than I could count.
And anytime there's some message about, reminders about, hey, Rhett needs this and that, how do you respond to that?
I usually volunteer to get it. If you're asking, if he needs something, just like soccer, I went and made sure that she signed him up for soccer, and I checked if I needed to pay for that. She had paid for it, so I asked if I could get the ball, the shoes, the shin guards. So I provided all that.
Okay. So would you say that you're working together basically
Yeah,
for the best interest of Rhett?
absolutely.
In
That's
that
what I try to
regard.
do every single day.
That's all the questions I have for now, Judge.
All right. Ms. Roberts, you may cross-examine.
you've been at the job that you've had since, these your glasses. Sorry, you might need them. So, Mr. Jones, you've been at the job with Toyota Material Handling since 2022. Is that correct? Is that what you said?
No, that's not what I said.
Okay.
I was saying that we,
Oh.
our, well, they call it the BOLD initiative, so it turned over to 4 days a week.
Okay.
That's all I was meaning.
Okay. That's what I was just.
Sure.
You, at the time, you and now Miss Maples y'all were never married and you had read out of
Correct.
wedlock.
Correct.
We came to court, I think you were represented by Jared Creasy, the now juvenile court judge, is that correct? Who represented you at the time?
Yeah,
And
I mean, we didn't go to court.
Well, again, the court entered an agreement.
Okay, sure.
When I say go to court, I didn't mean actually.
I'm not real familiar with them.
I apologize, that was inartfully put. But after y'all separated and were no longer living together.
Yes, ma'am.
You got a lawyer, she got a lawyer.
Right.
I represented her and Jerry Creasy represented you.
Correct.
And we entered into an agreed parenting plan.
Right.
Ms. Maples was designated as the primary residential parent, correct? And you got every other weekend, plus Mondays and Tuesdays because she worked late on those
Sure.
days. Is
Yes,
that right?
Mhm.
Excuse me. And then any other time that y'all agreed.
Right.
And for the most part, you and Ms. Maples worked well together.
Yep.
She kept you notified of sickness and doctor's appointments and, hey, he wants to do this.
Sure.
and Changing, I think there was an issue, maybe changing some daycare at some point in time or, getting enrolled in school. You knew about her getting married and all of that stuff, correct?
I guess.
And then
I specifically recall the daycare issue.
right. And then when your life changed and you became involved with somebody else, you made sure to cooperate and let her know, hey, we're serious, we're becoming and we're getting married,
Right.
and and Rhett was able to participate in
Right.
both wedding ceremonies, right?
Mhm.
Y'all were able to coordinate that so that Rhett got the best of both parents and got introduced to his new step parents.
Sure.
And again, there's not really any conflict in the fact between you and Miss Maples about communicating when it comes to, for the most part,
Sure.
when it comes
Absolutely.
to Rhett.
Yes, ma'am.
And at some point in time, Miss Maples changed her employment and became employed by the Dixon County School System, correct? You knew about
Yeah.
that?
Right. Well, way after that, but yes, I'm
Right.
aware.
And at the time, after the adoption of the parenting plan, you had left employment from material handlers,
Yeah. MHI.
MHI.
Yes, ma'am.
And then you got employed by
TMH.
Toyota.
Yeah.
And your initial time, you were still working, when you first went from MHI to Toyota, were you still working
It was the same.
5 days a week?
Yes, ma'am.
Okay.
Yeah. Mm.
But then Toyota decided to work,
Right. They adopted the BOLD initiative.
right, and that's when you became, and are you off on weekends, or when you said you work?
I'm always off a week.
Okay, that's what I wanted to make sure, because the way that you explained it, you work 4/10s with a rotating day off.
Yes, ma'am. Through the week.
Okay, and that's
So
what I
Monday
wanted.
through Friday. Yeah.
You don't work 4/10s. If you work Monday, Tuesday, Wednesday, Thursday, then you don't go, you're off Friday and then work 4 more days. I just wanted to make sure we understood
Yeah,
what your
it's
rotating
just-
schedule
it's
is.
just-
It's within the 5 days.
Yes, ma'am.
You're always off.
You could get called out on a weekend, but I don't ever.
Right.
It's kind of like they'll call and ask.
So are you off? You'll work Monday, Tuesday, Wednesday, Thursday, and be off Friday?
No, that's the rotating part. So if I would, let's just say I worked Monday my BOLD day was this Monday,
Uh-huh.
this week. So let's say I was off. So next week I'll be off Tuesday, the next Wednesday, the next Thursday, the next Friday.
Okay, that's what I'm saying, is you rotate, so you may work, you're off Monday, then you would work Thursday, Friday, you'd work Tuesday, Wednesday, Thursday,
Yes, ma'am.
Friday. So
Yes,
those are
ma'am.
your 4 days.
Yes,
Then the next week you would work Tuesday.
exactly.
So you would
Well,
work,
I'd be off Tuesday.
you would be
I'd
off
work Monday, Wednesday, Thursday, Friday.
Yeah, you would work Monday, off Tuesday.
Exactly.
They'd work Wednesday, Thursday, Friday. Then
Yes,
you'd be Monday, Tuesday, off Wednesday, work Thursday, Friday.
Right.
And then it rotates from that.
Yes.
Okay. And so when you changed and when y'all discussed this issue of changing where you would just get, instead of every other weekend and just having him on Monday and Tuesday from after school till she got off work at 7:30. Was the basis of that change her job change or your job change? You understand what I'm saying? Was a job change anything
I
about?
don't think it had anything to do with it.
Okay, that's what I thought. It was just a situation on where y'all discussed
Yeah, I mean, once again, it was a good communication.
good communication, and instead of kind of, you get every other weekend, it's like, let's give you 5 days every other weekend, in a bulk, so Rhett is there and not come back and forth so much.
Yeah,
And he's adapted well to that schedule.
yeah.
Your family has adapted well to that schedule.
Sure.
Y'all, have you changed Noah's time? so
That's
that his-
totally between my wife and,
If you'll let me finish my question.
okay.
You testified that Noah's father gets him every other weekend.
Mhm.
So my question is Noah's every other weekend consistent with yours in getting Rhett? Did y'all
Yes.
make sure that the boys
Yes.
are together?
We make sure that anytime they're together.
So the weekend, your wife, unless there's something that they agree separately, but consistently, routinely, Noah and Rhett are together at
schedule.
your house
Yes, ma'am.
on a Thursday through Tuesday.
Yes.
And then the next weekend, when Rhett would be with his mom for the
That's when
weekend,
Noah goes.
then Noah would
Yes,
go
ma'am.
with his dad.
Yes, ma'am.
Okay. And that's worked out, and the boys have done well with that?
Yes.
And that's
It's all
worked
been
out
good.
great?
Yes, ma'am.
And if I would, in looking at it, you've submitted, and I believe it made Exhibit 1. I don't know whether the W-2 and his year-to-date income, was that made one exhibit or two?
That's one exhibit.
Okay. Exhibit 1 had your 2024 W-2, which reflected your gross income at $61,091.49, I believe. Is that right?
Yes, ma'am.
And then your year-to-date for 2025 showed $25,387.32, if that's what's reflected on there. And if I counted right, you get paid on a Friday?
I think so.
Oh, well.
I don't ever look at it. I'm sorry.
That paycheck stub, I think, so I didn't bring it up here, but I think it had the, payday ending on May 2nd. My calendar, that was a Friday.
Okay.
How do you get paid? You get paid weekly, monthly,
Bi-weekly.
bi-weekly? So every 2 weeks you get paid,
Yes, ma'am.
and you get paid by direct deposit or?
Yes.
Okay.
That's all I'm saying. I hardly ever go in there and look at
Okay.
it.
But again, if I look at it on May 2nd, and again, in looking at your stuff, I counted, if you got paid Fridays, that's 18 Fridays from the
Okay.
first of the year until then. So you were on track this year. If I counted the 25,387.32 divided by the 18 weeks, that would leave you about $1,410 a week you getting paid times 52. You're on track to make a little over 73,000 this year.
Awesome.
Yeah.
Cool.
So my question, and again, we'll talk about the math later.
Sure.
I went to law school because there wasn't a math requirement, so again,
I'm with you.
yeah, whichever, if those figures are correct, you're on track to make, let's see, 9, 10, 11, about $13,000 more this year.
Okay.
So did you get a pay increase? Because you're making, it looks like you're making your hourly rate is $33.95 an hour
Sounds right.
right now. And did you get a pay increase from last year?
Probably, yeah.
Okay, do you know?
Not specifically, but
Are you scheduled to get, do they do pay increases
we just
with?
do like a yearly review, but you never get a specific. Like I know, I mean, my boss told me one year it was like 50 cents.
Okay. But again, they just do that across the board usually
Yeah,
annually.
yes, ma'am.
So again, if we're looking at you getting 30, and do you know when they do it? I just want to make sure your income.
I think
is
it's
correct.
in July or June,
Okay.
something like that.
So we can think about this May paycheck stub. You would have gotten your increase by January of 2025, and you might be scheduled for another increase in July, because a lot of companies do fiscal year rather than, you know.
Yeah, we do fiscal year, yeah.
You do fiscal, so from July 1 until June 30 is when they do it,
Yes.
instead of January to
Yes,
December.
yeah.
So you should, for the whole year of 2025, you're pretty confident that you are making $33.95 an hour.
Yeah, that sounds right.
Now, the summer under the parenting plan, y'all do the regular schedule, but each of y'all get an extended
week.
time. A week.
Right.
And y'all been able to coordinate and do that.
Yeah, and actually, some of mine's not even been in the summer. It's been in January most of the time. That's when we plan our vacation, so.
Okay. So there's not been any type of controversy
No, ma'am.
in doing that?
Nope.
Okay. Now, these messages that you put in, you just put in 2 text messages to show a couple of isolated instances when y'all got a little snippy, for lack
It's
of a
just,
better way to put it.
from where I've changed my phone over, I can only go through so many, but I tried my best to go through.
Well, I think the next one would be, were these made joint exhibits or separate exhibits, the 2 text messages?
Separate.
Okay, so I think the
We have a
first,
total of 3 text messages.
okay, the first one that we talked about, that you were questioned about, I wanted to go over.
It would be Exhibit 2. Do you want him to have a copy of it?
Exhibit 2, have you still got one, or did it get submitted in?
I have.
Okay. Is this the one, where she texts you, she's in the box and you're just on the plane, is that correct? If I could-
Yeah, yes,
Okay.
ma'am, yeah.
So this starts out a text from Hugh. This had nothing to do with us. We didn't care if all 3 of y'all were coaching on the same team. Aaron picked Rhett, I am guessing, because he had him last year. Did you go to the draft pick? Aaron had no clue that Justin was coaching and that you were helping. It's not Aaron's fault. Give him the benefit of the doubt. He had no idea you were involved with Justin. Who's Justin?
That's my buddy.
Your buddy? Okay. And so the predecessor to this this text message was, you got angry at her about the fact that Red had gotten picked up by this Aaron to coach his team.
Right.
And
When she
Aaron
knew I
had
was
been his
coming there to
coach the year
coach.
before.
Sure.
And then you had said you had coached him for years. That was your word.
I coached for years at Buckner.
And it was 1 year. He
I
had
coached him 1 year.
1 year.
Yes.
And then the year after that, you didn't coach and he was on Aaron's team?
Yep, he went to Aaron's team.
He went to Aaron's
Yep.
team.
That's when he moved to Charlotte.
Okay. And he went from Buckner where you coached him, and then the next year he went to Charlotte and he was on Aaron's team.
Right.
And Aaron just kept him. Correct?
He tried to keep him, yes.
He tried to keep him. But had you signed up officially to coach?
Yes. I did.
Or-
It was
or had Justin-
Josh Profit. You get 3 coaches in that age group. You had Josh Profit, Justin Adams, Josh Profit, and then it was me. So
And-
yes,
So again, making sure that we're clear on this, you had already signed up and run your background check and you were listed as a coach?
yes.
Okay. But you weren't at the pick?
No, I couldn't be at the pick. Only head coaches can go to the pick.
But you got mad at her because of something some other man did.
I got mad because she knew that I was gonna coach.
Well, but this draft in Charlotte, again, is not where they're pulling stuff out. I mean, the coaches just get together and do it, don't they?
They get to go in a snake draft. They pick the kids' names.
Right, without
Yep.
parents sitting there saying, pick
It's
my kid,
just
pick
head
my kid.
coaches, just head coaches.
Just the coaches. So how was she to know? I mean, why were you blaming her for y'all in the
Specifically because I reached out to Aaron directly and I asked him, had he had known, he already knew that I was coaching and he would be on my team. She had responded to me saying, or he responded to me saying that he had to reach out to her and ask her permission to let him be on my team.
And she said, and then this is her response. It was nothing to do with us. We don't care if all three of y'all coach. He just kept it. And then your response, yes, he did. Josh Prophet done the draft. I couldn't make it, plus I'm just an assistant. But Josh told him it was him, Justin, and me coaching.
Right.
Well, I don't know, Kyle. I didn't tell him to pick Rhett. I'm sure he didn't know. I'm just trying to be fair here. I am sure he will resolve it. He's an awesome guy. Is that right? I mean,
Yes. Yeah.
but you got angry at her over something like that.
And I probably went a little too far. I shouldn't have. I'll admit that.
But then you went on in the second page of that. All the drama is because you have issues with my wife. How about this? Don't ever say anything about my wife. You ever see or hear me talking about Jacob? Nope, never. But it's easy for you to disrespect my wife and family, and Rhett misses the chance for his father to be involved. That's what you want anyways. It's all on you, just like ripping him away from me by going to Charlotte. Keep him with Aaron. Don't call me for anything unless it involves my son. She responded, I don't have any issues with your wife, never have. I have never said anything bad about her because I don't have anything bad to say. You can coach your child. I have said this multiple times, Kyle. All I said was that I didn't want to be left out and for me to be involved with Rhett. I mean, why do you put your wife in the middle of it?
That was because there was an incident when I coached in T-ball.
2 years prior.
Yes.
So
She
you
got all bent out of shape because my wife came in the dugout to help for one game. Yes.
Which would have been a year and a half prior to this.
Yeah. Sure.
So you think you can't let stuff go?
Oh, I'm pretty good at letting stuff go. But
Okay.
I knew exactly what would happen.
And what was that?
She would raise a stink about my wife helping if she had to help.
The next text message. I just asked you first, but I have to go to Justin's for a little while this evening. I'm about to head there, but I was going to see if you cared if Kimmy picked up Rhett. I'll just keep him, it'll just keep me from having to go as well. If it's an issue, I'll just go anyways. Now, you had said on direct examination that you were already over at Justin's plant. But on this, it says, I'm about to head there. So were you not telling the truth on your direct examination that you were already
No,
there?
I was about to head to get Rhett.
Oh, you were about to head to get Rhett.
Yeah, I was just trying to make sure if it was okay if
Okay.
Kimmy could grab him.
And you know, and her text message, I can always pick him up and bring him to you. I'd rather do that. No, she could go pick her up and bring him to you. And then you got an attitude again, didn't you?
I just said that's not the point.
That's not the point. Don't worry about it. If it's such a problem, then I don't want anyone else picking him up either. You or Jacob. Not your mom, not anyone. She comes back, family can pick him up, Kyle, and I don't mind picking him up and bringing him to you. I'm at home.
I noticed that Ms. Roberts' dramatic reading of this, she tends to emphasize her client's reading of
Nice.
that in a very calm manner, and yours is a very angry.
Well,
I want you to understand that's just part of being a good lawyer.
I always say this is very hard, and it's nothing against anybody, but it's really, that's the problem with text, is you don't
Well,
know
I
the
agree with
emotion.
you. Some
You
of the
don't,
worst
you don't know the
conversations
emotion, and for me, it's like I'm trying to go back and,
Well, I'm just pointing out the fact. that
I know, I'm fine.
I've known Ms. Roberts a long time, and I'm well aware of that. There's nothing wrong with what she's doing, but I'm
Sure.
aware of the fact that in her reading, you come across a little harsher than her client. But the fact of the matter is that text messages don't always convey.
Exactly. Yes,
That's why ideally people could pick up the phone and talk to each other instead of text
yes.
messaging.
Judge Wolf and I are of the generation who,
I know.
we didn't have text messages for a long
Y'all
time.
have some beepers?
And beepers was, that was it, so,
You're due.
uh-huh. But
You're
again,
I'm not sure how to take that. So,
but it's true. That's the problem.
sometimes the truth hurts.
Yeah. But again, she offered the kid, again, the whole point is
Yes,
that
ma'am.
you said, hey, can Kenny pick him up? She says, hey, I'm at home, I can bring him to you.
Yes, ma'am. And coming back and reading this is like, I don't know what I had going on that day. You know, I don't know why I got upset, because I should have just said, yeah, I mean, if you want to grab him. But I don't know. I just, for whatever reason, I was just saying if one of our friends, she's met him, you know, could just grab him, they're coming right back. I honestly, I have no idea what was going on that day.
But again, just like you're asking today, if she picked him up and brought him to you, she could spend a few minutes with y'all's boy.
Sure, and I understand that. That's fine. Yes,
And
ma'am.
again, but you, text message, things like that, you got to the point where you can't, and you text, your mother is not to pick him up, period.
Right.
And you understand that's a way overreaction.
Sure. That's very harsh. Yes,
I
ma'am.
mean, you know her mother, she's worked for the
I do.
school board for years and years.
Yes, ma'am.
She has a teacher's, schedule,
Yeah.
and you retaliated by just saying, nobody's gonna pick him up. But no point in time did Miss Maples ever retaliate and say, okay, well, then your wife can't pick him up.
No,
She didn't.
no,
She didn't retaliate, did she?
she did not.
And again, you picked these two things out, and they're an anomaly, if you would, because for the most part, y'all don't get into this
No,
kind of
it's not
griping
often at all.
contest.
Nope.
Y'all are able to set aside you want your child with you 24/7, but you understand you got to share.
Sure.
And for the most part, y'all are able to do that.
For the most part, yes.
And if something changes and one of y'all have something coming up, y'all typically can call one another and
We
say, hey,
usually let
look,
each other know way in advance.
this is happening, can I get him today rather than tomorrow? And y'all both do that.
Yes, ma'am.
Now, this baptismal thing.
Mhm.
And again, as Judge Wolf pointed out, you didn't ever just pick up the phone and call her, did you? You text.
Yes.
And the text message that was submitted in here looked like we talked about it the night before, and he got baptized today.
Right. Yeah. I mean, I see how it looks, but again, as far as like speaking it, he had overheard the conversation about baptisms. He asked me what a baptism was. I let him know what a baptism was. Sporadically, the day that we did an altar call, that's when he looked at me and said, Daddy, can I be baptized today?
Okay. And he was 6.
I'm not ever going to tell my son no. I mean, unless it's something bad. But
Well, again, did you ever consider and saying, hey, Nanny and Papa and Mama and
No.
and all them
No.
want to be here, and
It has
let's
nothing-
schedule a time to do it.
ma'am, it has nothing to do with my parents. It has nothing to do with her parents, me, her. That was his decision with God.
Well, but again,
That
the
was his
parenting
decision with
plan
God.
says that religious decisions will be joint, and if you can't agree, after discussion, that she gets to make the decision. Aware that the parenting plan says that?
I don't guess I read that part.
Okay, and you understand that she was raised up in church. And you were. Were you raised up in church?
I was, yes.
Okay, and you understand that she was? That
I
Do
don't
you?
understand that. No,
you didn't know that she attended church?
no, ma'am. When we were together in the years that we were together, we went to church 2 times a year.
So neither one of y'all went?
No,
Okay. But were you familiar with her family and that they went to church?
I knew her mother went to church.
Okay. And you understand that that commitment was one that y'all should have made together?
Again, it was sporadic. It was not planned by no means, so. And I felt bad for that. I felt bad about that. I can't take it back. That was just a decision for him. If I would have known, they would have known, my mom would have known. all
Well,
my
you said
family
it
would have
didn't
known.
matter.
If it was planned, then I would have invited them. I would have invited her. I would have invited whoever. But it was not planned. There wasn't nothing I could do about it. So I did the best I could and took a video. And that was it.
Now, your child's due at the end of July, end of July. And you've not had any, this is your son, Rhett, is your only child right now, and you're expecting
Yes.
a daughter with your current wife.
Mhm.
You have no afterborn children. Who keeps health insurance on Rhett?
I do.
And do you have the cost associated with that health insurance?
There's a breakdown in my ADP, and I think I shared that.
Well, you understand, we filed this petition back in July of last year, of 2024, asking for a modification of support.
Okay.
Okay, do you understand what the support is considered? How much the child is with you, how much the child is with her,
Sure.
the cost of health insurance, cost of daycare if there is any,
Right.
and then, and again, any before-born or after-born children. And you don't know what the cost of your health insurance is today?
$200 and something every other week.
You don't know, you didn't bring that to court with you today.
I didn't.
You didn't submit it during your direct examination.
Yeah, pretty sure I did.
I'm sorry, when did you submit it during your direct examination? The cost of your health insurance?
I supplied it to my lawyer. I don't know. This has been going on for like a year.
Okay. Well, again, I just wanted to make sure that you submitted a paycheck stub that shows, but you have family coverage, correct?
Mm-hmm. I have his card in my wallet right now.
Well, again, who's covered under your family coverage?
My son and myself.
Okay, does your wife have separate insurance?
Yes.
Do you know how much it costs for you to have separate insurance? If you just had single insurance, do you know how much it cost?
It's half of that 200.
Do you know that, or you guessing?
No, I asked my HR yesterday.
Have any documentation from
A
them?
text. I have a text. And they submitted it, or 2 days ago, I sent it to Miss Ellen. She may have the text.
Okay. And again, from July of 2024, when we filed this, you have effectively been getting your child 10 days a month. 5 days 1 week and 5 days.
Yes. Yes. Yep.
Okay.
Sanderson, you have redirect?
So Ms. Roberts asked you about when you all changed the schedule to Thursday to Tuesday. You were asked why you all did that. Can you clarify, why did you ask for more time with your son?
To spend more time with him.
To spend more time with him, okay?
Yes, ma'am.
And did your change of schedule in your work schedule allowed you to do that?
Yes.
Okay. And do you believe that is in the best interest of Rhett for you to
Absolutely.
spend more time with him?
Yes, ma'am.
Okay. On the baptism issue, would you have had the time to call Mrs. Maples when it was happening in real time?
No.
And you were asked by Ms. Roberts about those text messages that we filed with the court. And again, I asked you earlier, Those two messages were isolated incident, right?
Yes, ma'am.
And I do have some text messages here that's more recent. I'd like for you to go over that and tell me, just identify those text messages. I'm not gonna make you read all of that, but tell me.
Appear to be outside the scope of redirect.
Judge, so this is basically a rebuttal to Miss Roberts' questioning regarding the communication.
What's the purpose of showing these messages?
Basically, these are text messages that are, it's showing the cooperation between the two of
I don't
them.
think that's really an issue. I think even Ms. Roberts in her cross-examination indicated that they were getting along. And I have seen enough text messages, like in the case that occurred before us, before lunch, the case that we had, where the gentleman used profanity that, was just unacceptable. That's one direction. This is the opposite end. This is two people who otherwise get along, and there was some disagreement. It was a civil disagreement, and I don't find anything that was in the examples you've given to be particularly offensive, although it's, certainly shows that there was some, something that was upset, and the idea that he could exclude her mother from that was inappropriate. But I think it was acknowledged, even on cross-examination, that that was something out of the ordinary and that they usually got along. So I sustain the objection. I don't see any purpose in introducing these others.
Understand that, thank you. On the health insurance coverage, so what was it that you testified with regards to how much is your payment for your health insurance for you and Rhett?
It's like, I think it's $200-something biweekly.
The exhibit that we entered, that was statement for May 2, 2025, it states $256.07. Does that sound right to
Yeah.
you?
Yes,
And
ma'am.
that's a bi-weekly payment?
Right. Yes, ma'am.
And you testify that half of that would be towards Rhett's contribution?
Sustained.
What would be the contribution just towards Rhett?
Hunter needs that information. I questioned him about it. He is entitled to receive it.
Whatever I rule on the, excuse me for interrupting, whatever I rule on the modification of the parenting plan, the calculation of child support is going to be based on current income information as well as information, even if it's not supplied today, I'm going to order it to be supplied to break down, the cost of medical insurance for him. Some verification needs to be provided so that we know exactly what he's paying and how much it costs for family coverage versus individual coverage. It's not usually a 50-50 split. It's not usually $200 for both him and his family and $100 for him. It's usually something different than that. So we're just gonna, there's really no reason to go through a lot of that because when we're finished, I'm gonna require you all to exchange the current information and calculate everything on basic current information, so.
Yeah, Judge, he did try to get that exact number, and the HR was not able to give him an exact number. They just told him it's 50%.
Doesn't matter, I'm gonna require them to give an exact number. I'm not assessing blame for that, I'm just simply saying whether that's been supplied, whether he attempted to get it or not is academic to me. My question is, how much is it and how can we determine it? And that's why I'm saying I will put an order down that will say that, the calculation of child support needs to be based on all of the current information, and your parties will exchange information and agree on the calculation, because once we get the figures, then it goes into this computer that the state has now given us, and it should be it should be the same amount, whether you figure it or Ms. Roberts figures it. So,
That's all the questions I have, Judge.
all right. Thank you. You may step down. Ms. Hendrickson, you may call your next witness. Then, so.
Judge, I call Miss Kristen Jones. She's outside. Thank you.
You appear by Zoom. So when you're saying, excuse me for just a sec, when you're saying that the case I set this morning, you're talking about the motion to continue, Mr. Yeah. Oh, the motions. Gotcha. Okay, never mind. I'm with you. Thank you.
Mrs. Jones, please state your name for the record, please.
Kristen Jones.
Okay. And you're married to Mr. Jones?
Yes.
And you have a son named Noah, is that right?
Yes.
And how old is Noah?
He's 12.
And he primarily resides with you?
Yes.
Okay. And how long have you all been married?
Since August of 2020.
Of 2020, okay. And you're with a child right now?
Yes.
And when are you going to be due for your
July.
child? In July, okay. Describe to me your relationship with Rhett.
We have a good relationship. We play Uno, we play aggravation, we put Legos together, we go to the splash pad, we go to the trampoline park, we go skating. He's a good helper in the kitchen. We'll put cookies and brownies together. He enjoys that. We have fun together.
Okay. What is aside from that, what can you tell us what is your participation as far as the care of Rhett when he's with you all in the household?
I help out when is needed. Sometimes I'll pick him up from school. Sometimes I'll drop him off at school. Sometimes I help with his lunches, things like that.
Okay. And describe to the court the relationship between your son Noah and Rhett.
They're attached to the hip. They do everything together. They will play baseball, basketball, football outside. Noah has been helping him with soccer. They go fishing. They go swimming. He's teaching him how to tie shoes. And here recently, he's been, sorry, I'm nervous. He's been working with him with the Rubik's Cube.
Okay. And you're doing fine. So have you witnessed the communication between Mr. Jones and Mrs. Maples?
Yes, I feel like they communicate very well majority of the time, 99% of the time. They are great co-parents. They can go to events, school programs, communicate well. They can FaceTime Rhett and we'll communicate together, and it's almost like this right here is not even happening.
Right.
They put Rhett's interest first.
Both parents do.
Yes.
How's your relationship with Mrs. Maples?
It's good. She has my number, I have her number. And there's been times where I've kept Rhett and she's contacted me I don't have FaceTime, but to talk to him.
And then can you describe the relationship between Rhett and Mr. Jones?
Kyle is a very involved parent. He shows up to all of his school programs, all of his sports events. He's coached almost all of the teams that he's been on. He takes him hunting and fishing. He takes him to Jackson to visit his family. He takes him to church. He takes him on trips. They are attached. All three boys are attached whenever they're together.
That's all the questions I have, Judge. Just stay there, and Ms. Roberts, I
Okay,
have
I'm sorry.
questions.
All three boys are attached. The three boys were the 7-year-old, the 12-year-old, and the
Yes.
how many-year-old sitting over here?
Yeah.
I apologize, I kind of
He's a
snickered
kid
when
at
you
heart.
said the boys are attached, that you put your husband in that same.
I'm sorry.
Where do you work, Mr.
I work at UBS in Nashville.
And what are your hours?
So I work from home, so it could be from 6 in the morning till 2 in the afternoon, or it could be, I actually go into office Tuesday through Thursday, and I work from home Monday, Friday. But my boss is very lenient, and our schedules are pretty flexible that we can.
Well, that's what I thought when you said you worked at UBS. Again, I'm trying not to be as literal as that sounds. You
Yeah.
actually work for UBS,
Yes.
and you work from home at least 2 days a week and go
Yes.
into the office 3.
Yes.
Okay. So you're not the traditional Monday through Friday, get in the car at
No.
6 o'clock to drive to Nashville and beat
No.
the traffic. You have
And right. So if I need to help out, they're more than welcome. Yeah,
okay.
it's open.
And so how long have you and Mr. Jones been together?
We started dating December 2019.
December 2019.
Mm-hmm.
And again, y'all married when?
August 2020.
August of 2020. And so when we entered the parenting plan, were y'all just engaged or were y'all already married?
The parenting plan was May, right?
Uh-huh.
We were just together.
You were just together?
Yeah.
And y'all didn't ever live together before
No.
you married because again, there was a provision in there
And
not to.
that's right.
But you've been involved in Rhett's life even before y'all started dating in 2019.
Yes.
And you got introduced to his son.
It wasn't till later.
Right, but
Right.
still you got introduced to his son. And
Mhm.
you've been involved in his life effectively ever since, even before the parenting plan was in.
Yes.
And y'all married, you moved in together, and you've been a part of his life since
Mm-hmm.
And again, because of circumstances that changed, and Rose's job changed, and Kyle's job changed, they morphed into this where he's getting a bigger block of time with Red. And that's worked out wonderfully for this young man, hasn't it? It's allowed you to become an effective step-parent and help out, correct?
Right.
It's allowed your biological son to bond with your husband's biological son.
Correct.
Miss Maples and Mr. Jones, even though there's little glitches here and there that everybody gets with, but as you said, 99% of the time, they are effective co-parents.
Correct.
And Red has flourished as a result
Right.
of that. He's doing well in school.
Correct.
He goes to Van Leer.
Correct.
I think Noah, does he go to Burns?
He goes to Nashville Christian.
He goes to Nashville Christian. Okay. So do you drive him?
I take him, yes.
You take him to school at Nashville Christian. And then you're scheduled to be, how long a maternity leave?
I won't go back till January,
Are you off now?
not till July.
Not till you get closer to your due date. And then you've taken the rest of the year off.
Correct. That's the great benefits of UBS.
And when you say taking off, you're not working from just home. You're able to just not work at all.
I'm off.
Right. And Miss Maples is able to communicate with you and to,
It's open, yes.
It's
We
open.
have each other's phone number.
okay. And there's not, as far, you don't, she's kept y'all involved through what you've observed.
Right,
If Rhett's sick and needs a doctor's appointment, she lets him know.
right.
And you agree with me that Rose is the one that effectively schedules Rhett's doctor's appointments and follows up with those things?
Yeah.
Although she discusses it with your husband.
Correct. And there has been times where Rhett has been sick with us and Kyle's taken him to the doctor as well. It's
And, you know, they discuss signing up for extracurricular activities.
right.
And there's not an issue with you about your husband coaching and being involved in Rhett's situations, right?
No.
And as I said, Rhett has flourished with his current schedule. Is that correct?
He does well.
Okay, thank you.
Sounds to me like, you probably don't know this, but I lecture the couples all the time when I'm in court here with them. And I tell them that they need to behave exactly like what I'm hearing these two pretty much behave, and you behave in the scenario as a new person in that relationship. So I just want to say thank you for at least being the kind of person, and her being the kind of person, and him being the kind of person that it seems to me that I have encouraged over the years people to try to emulate and be like, that you all have to seemingly, at least, without, I mean, nothing is perfect. There's no relationship of any kind, even between husbands and wives, that don't have their bumps in the road. And so I certainly understand that, but for the most part, it sounds like they have a good relationship, and that you're helping your husband and facilitating that good relationship between the two of them. So thank you for that. You can have a seat. Ms. Hendrickson, you may call your next witness. All right. You can have a seat in the courtroom if you'd like. Well, if you raise your right hand and be placed under oath.
Mrs. Maples, you're not off the hook.
Well, that's okay.
Please state your full name for the record.
Rose Hannah Maples.
And you all have a Rhett, Mr. Rhett, 7 years old, correct?
Yes, ma'am.
Okay. And I just want to confirm, your lawyer basically agreed to the Thursday to Tuesday, is that right?
Yes,
You
that's
don't have a
correct.
problem with that?
I do not. Nope.
Okay. And so you don't have any concerns about Rhett's well-being when he is with Mr. Jones, is that correct?
No, ma'am.
Okay. So do you believe that Mr. Jones effectively cares for or provides for the needs of Rhett when he's with Mr. Jones?
I feel like most of the time, yes.
Okay. So what would be the reason why he should not have the 7 days instead of the
I
5
feel like
days?
right now with our child doing so well and flourishing so well, that this schedule will work for us. I feel like if major changes happen, our child is he likes to know what happens, what day is this, what day is that. So us changing schedules is rough on him anyways. So with him doing well with this schedule, I feel like why change something that's not broken?
Okay. But he did flourish, and would you agree with me that he seamlessly adapted to the change from the every other weekend to the Thursday
I
to
don't really
Tuesday?
consider that seamlessly. We
Okay.
had different conversations when he was at home,
Mm-hmm.
not understanding the times, and sometimes he gets upset when he has to leave, and I think sometimes he gets upset with just schedule change in general. So
Right.
now that we have gotten him over the hump of the schedule change, I would not like to put him back into that where he is worried about, well, what day is this, or what day is that. I would like to keep it the same, just so that way we do not ruffle his feathers and put him back to where he was before.
But would you agree with me that coaching him and making him, understand that it might be good for you to have an equal time with your mom and dad? Is that something?
Sustained, I don't think the question is an appropriate question for her to be asked.
Okay, Judge. Let me rephrase. So would you agree with me that over time, if, the same way as he was able to adjust to the Thursday to Tuesday, that at some point he'd be able to adjust to the 50-50? Judge,
Question
he
is-
knows this. May I respond to that, Judge?
Yes, go ahead.
Judge, the mother knows her son, so I believe that she would have some input on how her son will do in the event that we change it to 7 days on, 7 days off. I just don't think that she wouldn't have any idea how her son will fare. I mean, she already testified to it that, he doesn't like this change and things of that nature. So I don't understand why she can't provide her own opinion on that.
I mean, she has already stated that she opposes the 7-day on, 7-day off schedule because the schedule that they have right now works so well, and that the child did not adjust seamlessly, as you put it, to the change when they made the change, and that they've had many conversations, and that she doesn't think that he would do well to make a change at this point. And her exact words were, "Why change it if it's not broken?" So I think she's answered the question about that in attempting to ask her to speculate whether or not the child would do well under a 7-day on, 7-day off is academic. She opposes it. So the question is whether she would think he does or doesn't do well with it. It's already been answered. She doesn't think he's going to do well. Sustain the objection.
Understand, Judge. So but you would agree with me that because of the, and you allowed it, very gracious of you to allow the Thursday to Tuesday schedule. Would you agree that Mr. Jones have been participating more in your son's life?
I feel like he participates well in Rhett's life.
Well, okay.
I feel like with the schedule that we have adapted, him and I worked together on that. That wasn't just a me or a Mr. Jones decision. That was what was decided. So the dates were not so sporadic,
Right.
and that Cal was able to get more time with Rhett, and we knew that also with school schedule when he was going into kindergarten, it was going to be a different world. It was
Right.
going to be in daycare. Daycare is a different world than going into school. So
Right. There's a lot of changes there, right?
right, and so with the changes, it's been great, and so I feel like we need to stick with what is going well.
And that you just testified that, you felt like more time for Mr. Jones is appropriate for Rhett. Is that right?
Well, I feel like the time that he has been allotted has been great for both of them.
Okay. So the more time that he's spending with Rhett has been good for Rhett. Is that right?
I feel like they enjoy their time together, and it is, I never want to keep my child from his dad,
Sure.
and his dad knows that.
Right.
But we also need to have a stable schedule, and this is our stable schedule.
Okay. Would you agree that Mr. Jones has also been outside of the child support, which was the $200-something a month for now? Has he been providing outside of that?
Not necessarily, no. My husband pays for a lot of things, and before we ever even came to court, I had reached out to Mr. Jones and said, hey, Red is growing and things are getting more expensive, and can we just kind of reevaluate? Like, I'm needing more support from you. And he did not even answer that message for me. I have asked for more support from him, and I haven't gotten it. Now, there are times where I will ask him, hey, will you run by and get this? And he'll do it. But it is not an offered help.
Okay.
It is only offered to me if I ask him for help.
But in the past, and I have text messages where he would tell you, hey, I want to give you $100 for this and that.
Well, it's very seldom.
Okay.
That's not a common
Okay.
thing. And when him and I had discussed initially, I wasn't at, him and I had discussed that when Rhett went to school, the child support would look different just because he's not paying for daycare anymore. And so I said, hey, for us both to not go back, I just need more support from you on the other half end
Understand,
to
but
make up for the support with the daycare. Have I fully received that support? Absolutely not.
so do you recall that text message that you sent him about the child support?
Yes, I do. And I have it and we've sent it.
This was sent March 17, 2024. And you said things are getting more and more expensive, so I have spoke with my lawyer and I need more financial support from you for rent. $204 a month is not helping at all. There are two options. You and I can decide on a price together, and that is what you can start paying in April. The other option is you will need to send your recent check stub, and then you provided Ms. Roberts' email, and she will put it in the calculator and will go off that what says for you to pay. This will not be an argument nor a fight. This is what you are doing. Once you decided on which one you would prefer, then you can communicate that with me. Was that the text message you
Yes,
sent?
ma'am,
Okay.
it was.
But you never factored in the fact that he was spending more nights than the every other weekend. Is that right?
He was only spending a few more. We changed the schedule around, so it wasn't like he added great enough time for $204 a month to be sufficient enough for us to take care of Rhett.
Okay, so I understand that, but what I'm saying is, in the original parenting plan, he only had 2 nights every other weekends, the Friday night and the Saturday night. So that's what's counted for him, 90 days. In your text message, it doesn't give him the credit for the 5 days that Rhett is staying with him. Would you agree with that?
I mean, I don't think that.
Well, the text message itself does speak for itself, and if that's being produced for her to review, then she can review it and determine whether or not there's anything in there. But the calculation of child support under our current law is not just based on incomes, it's based on the number of days each person has, and it also is based upon other considerations such as daycare expenses, work-related daycare expenses, health insurance, premiums, and so forth. So it's not a simple matter of you make this, I make that, you make that amount, I make this amount, so you ought to pay me this amount. So, but I'm not sure that I would sustain the objection because I don't think that she's asked her anything inappropriate, but the text message itself does speak for itself. So refer to the text message in answering her question.
Mrs. Maples, can you identify that text? Was that the text that you sent to Mr. Jones?
Yes.
With regard to the child support?
Yes.
Okay. And it's dated March 17, 2024?
Yes, ma'am.
Okay, was that text, was that before or after y'all tried to do mediation? I can't remember. Do you
We
remember?
tried to do mediation a long time ago, and his previous lawyer was never able to make it in.
Right, so even as early as before that date, you were all just trying to mediate
Well,
and see.
our agreement was our agreement with us not having to go back to court,
court, yes.
because I tried to avoid that, was I just need you to help. I need you to really help.
Sure.
And yes, there has been help, but has it been minimal? Yes. It's not a substantial amount of help that I have received.
Okay, but what you would agree with me, in looking at that text message, you basically gave him two options. Either you agree on a price and that'll be set, and it was supposed to start in April, or he gives his paycheck to Miss Roberts and it will get calculated. So the other factors that Judge Wolf just enumerated that goes into calculating the child support, that was not provided in your text here, correct?
But whenever I say to
It's a
put it in
yes or
the
no
calculator,
question.
it puts it in. It will put the days
Yeah.
in, correct?
Only
If
the
you put it in
days-
the calculator.
Only the days that's in the current parenting plan, not the days that he's actually spending.
Sustained?
So you would agree with me that the parenting plan only assigns 90 days to Mr. Jones, is that correct?
Yes.
Okay, and so in your text message, you're just asking him to provide his own paycheck and that will be put in the calculator, is that correct?
Yes.
Okay. Judge, I'd like to put that into evidence.
Mark it as the next exhibit in order.
Now, there's a lot of talk about your communication and everybody's, including me, I commend you and Mr. Jones for having really good communication. And so do you agree with that characterization of y'all's communication?
I feel like we communicate fairly well.
Okay.
I feel like sometimes he can be hot-headed, but that's just his nature. But I feel like 98% of the time, we communicate very well.
And in fact, just this recent, last week, I believe, y'all were able to come up with an agreement on them going to Florida
Yes,
today.
and I'm all about, if they're going on a trip, to make sure it lines up and they can go. I never want to keep my child from having a vacation with them, because he does love them.
Right.
He needs to get to go with them just as much as he does us.
Right, right.
So anytime that there is any kind of communication about going here or going there, we always discuss it. We make sure that that doesn't interfere with his school time. And if
Right,
it doesn't
yeah.
interfere with school time, then I feel like he can go.
Right, yeah. So aside from your concern about Rhett having to adjust, are there any other concerns as far as our request for the 7 days on, 7 days off?
Just him, I just don't feel like he will do well. And that's my only concern, is my child.
But you don't know that though.
Sustained. You ask her the question, she answered, and then you say she doesn't know the answer, so sustained is argumentative.
So your reason for not agreeing to the 7 days on, 7 days off is that Rhett? I'm not talking about negotiations. I'm just trying to follow up a question from her answer.
And what is your question again?
Her objection to the 7 days on, 7 days off was because of the adjustment issue. And then I'm gonna follow up with a question. So it doesn't have anything to do with negotiations.
Ask your question.
So aside from that, you don't have issues with Mr. Jones in general, because nobody's perfect, right? But in general, you don't have any issues with his parenting skills. Is that right?
No, I don't have any issues with his parenting
So
skills.
you trust him to provide for, the day-to-day needs.
I feel like when my child is in his care, that with the help of Kristen, his wife, that Rhett is 100% taken care of.
Okay. And in reality, the reason why you don't want to agree on that 7 days on, 7 days off is that you just cannot go longer than the 5 days. That's what you communicated to Mr. Jones, correct?
I don't want to go longer than the 5 days, and I do not think that my child will do well going longer than the 5 days.
Understand that. But you understand it's not about you, it's about the welfare of your son.
Right, and I also
correct?
stated that it is about the welfare of my child, and that I do not feel like he will do well with that schedule.
That's all the questions I have.
All right, Ms. Roberts, you have a question?
I live at 1579 Bell Hollow Road in Van Lear, Tennessee. It is me and my baby, and Brett and my husband Jacob.
Okay, what's your baby's name?
Collins Maples.
And what is Colin's date of birth?
Her date of birth is August the 19th of 24.
Okay. Now, you and Mr. Jones had Rhett back in 2017.
Yes, ma'am.
And y'all were not married. is
No,
that
ma'am,
correct?
we were not.
And y'all were together for how long a period of time? When did y'all separate after you?
We were together probably about 1.5 years, and then we separated.
Okay. And at that point in time, you retained me, and I think he retained
Judge Creasy.
Judge Creasy, the now Judge Creasy, and we were able to work out an agreement in a parenting schedule. Is
Yes,
that
ma'am.
correct? And where did you work at the time?
I worked for Lucas Orthodontic Group out of Brentwood, Tennessee.
Okay, and he worked at this
MHI.
MHI. And we entered into this agreement where he got every other weekend and then could pick the child up on Mondays and Tuesday afternoons. You worked like, you typically would work a late.
Yes, ma'am, we were on an alternate schedule.
Okay. And you changed employment.
I did, yes, ma'am.
And where are you working now?
I work for Dixon County Board of Education. I work at Burns Middle School. I've been there for 2 years.
Craig,
Yes, ma'am.
may I pass that?
No.
Thank you.
I've handed you a couple of documents, and can you look through those and see what they are?
That's my W-2 and my check stub.
Okay, so your 2024 W-2 is the 2-page that you, we copied it on 2 pages.
Yes, ma'am.
And what was your income for 2024 under your Social Security wages?
It was $19,152.81.
And again, you have now your paycheck stub with your when you started the school year for 2024, 2025, which we just finished. And is this the current paycheck stub? I think we have dated for, the check date was 5/20. Is
Yes,
that
ma'am.
correct?
We get paid monthly.
Okay, and so, and your year-to-date income, gross pay, again, was $9,476.65. Is that
Yes,
correct?
ma'am.
And so that's what you've made from January through May?
Yes,
Is that
ma'am.
right?
Yes, ma'am.
Your Honor, we'll move that in as the next exhibit.
All right, working is 6.
Now, Ms. Maples, you agree that at some point in time, you and Mr. Maples, in looking at the child's best interest, decide to modify the existing parenting plan. Is that correct?
Yes.
And y'all were able to agree to do that. Is that right?
Yes.
Again, under the existing parenting plan, he was to get the child 90 days, which was the father would have residential time every other weekend from Friday at 6 to Sunday at 6. And it goes on to say, and any other times the parties may mutually agree.
Yes, ma'am.
And additionally, the father may pick up the child from daycare on Monday and Tuesday afternoon and keep him until the mother gets off at 7:30.
Yes, ma'am.
And did he usually and customarily pick him up on Mondays and Tuesdays?
Yes, ma'am.
And then the every other weekend, and even y'all were able to agree to a bigger block of time. And when did that happen, ma'am?
That happened July of 2023, right before Rhett went into Kindergarten.
Started kindergarten?
Yes.
Okay. And so, and he's going to kindergarten in Vandalier, is that correct?
He went to kindergarten. Yes, ma'am. He's
Okay.
going into 2nd grade now.
Right, but he's still at the Vandalier school?
Yes, ma'am.
Okay, and
Yep.
that, is that where you're zoned for?
That's where we're zoned for. Yes,
Okay.
ma'am.
And so y'all changed that by mutual agreement, and y'all agreed, and you're consistent with the parenting plan that says any other times that the parties may mutually agree.
Yes, ma'am.
Then if you go over, when we, on the, if looking at the parenting plan, your income at the time was $2,357.33 a month, and Mr. Jones's was $3,213.
Yes,
And
ma'am.
we calculated child support based on those numbers, is that correct?
Yes, ma'am.
But was Mr. Jones supposed to pay all of the daycare expenses? It wasn't put into the calculator, was it? He just paid the daycare directly,
He
correct?
paid the daycare directly.
And he was supposed to keep health insurance for the
Yes,
child?
ma'am.
Okay. And y'all split any health insurance equally between y'all,
Yes,
50/50,
ma'am.
is that correct?
Yes.
But you were familiar, and it was discussed with you, that under the child support section, and I can pass this to you, that the parties acknowledge that court approval must be obtained before child support can be reduced or modified.
Yes, ma'am.
And you were aware of that when you signed that.
Yes, ma'am.
So at some point in time, after you changed, when you were changing jobs, did you know that he changed jobs too?
I did not until later on.
Not until later on, but did you reach out to ask him for a modification of support as evidenced by exhibit number 5?
I did.
The text message?
Yes, I did.
Before filing a petition to
Yes,
modify the child
I
support?
asked to reach out before filing.
Okay. And again, you understood through the parenting plan that you had to have a court order to change
Yes.
the money, but y'all
Yes.
were free to agree on
Yes.
additional time?
Yes.
Correct? And did he ever respond or do anything back to you?
No, ma'am.
And as a result of that, did you incur attorney's fees
I
and
sure
costs
did.
to have to do that?
Yes, ma'am.
And is it true that you were, that you signed a contract with me to pay $350 an hour for
Yes,
the
ma'am.
time that was associated with getting this case done?
Yes, ma'am.
And after we filed that, they counterfiled, correct?
Yes, ma'am.
And prior to doing that, he had a previous attorney by the name of Kelly Jackson Smith, is that correct?
Yes, ma'am.
And were there a number of times that we attempted to reach out and try to mediate this
Yes.
matter? And
Numerous times.
again, those were canceled or not being able to take
Yes.
care of, is that correct?
Yes, ma'am.
And again, not putting fault on anybody, but it just didn't happen, did it?
Right. Yes,
So
ma'am.
did you try your best to resolve and modify
I've tried multiple times. Yes, ma'am.
before having to bring this to the court?
Yes, ma'am.
Okay. And you've incurred attorney's fees as a result of that.
Yes, ma'am.
Now, you believe that you don't have a problem, and again, it's been questioned, the existing schedule is best for your child.
No, I think that would be best.
You've worked it out. And again, one of the things that we didn't do back at the time, he was ordered to pay child support in the amount of $204 monthly.
Yes, ma'am.
And has that been does he pay that consistently?
No, he has to be reminded often.
Do you want a due date specifically
Yes.
set? And do you want it paid by wage assignment through the registry of the court?
Preferably.
Okay. But until the wage assignment goes into effect, you want a due date so you know the time that you're getting your child support?
Yes.
Because as we're sitting here right now on May 20, what's today, the 28th? I
Yes,
guess,
ma'am.
Have you received child support for May?
I have not received child support for this month. No, ma'am.
Have you asked him about it?
No, ma'am.
But again, you'd like it on a specific day,
Yes, and I'd like to have to not remind.
not have to remind.
Yes, ma'am.
Okay. Now, we filed this petition in July 2nd, and you were aware at the time you had had a change of job, and he had had a change of job at that point in time, correct?
Yes, ma'am.
And were you pregnant at the time?
Yes.
And so you knew come August, I think we alleged that in August you would have an afterborn child.
Yes, ma'am.
And you now learned that he is about to have an afterborn child in the end of July.
Yes, ma'am.
And all of those factors you've been explained and understand that those are the things that the court has to consider.
Yes, ma'am.
And you think the 5 days, twice a week, at 10 days a month is appropriate for him.
Yes, ma'am.
And your child has flourished with that.
He has. Yes, ma'am.
How's he doing in school?
Oh, he loves his school. We love Van Lair. That he has done really, really well.
He's making good progress.
He's making great progress.
Does
Yes,
he have
ma'am.
a set of social friends there?
Oh, he has all kinds of little friends that he's even had since pre-K.
And you think that it's appropriate to continue the schedule?
Yes, ma'am. I sure do.
I believe that's all. Thank you, ma'am.
Thank you.
We need to redirect Ms. Henderson. Thank you, ma'am. You may
Thank
step
you.
down. The rest of their proof, we'll take a recess for the afternoon for 15 minutes.
All rise. Court's now in recess for 15 minutes.
Do you look at that text, and is that between you and Mrs. Maples?
It is.
Okay, and what date is depicted on that text message?
June 22nd, 2023.
Move up
Okay.
to the, pull that
Sorry about
microphone
that.
towards
There you go. Better? Sorry.
Can you read that first message and tell the court who's that from?
So I had initiated a text with her and said, well, so now's the time we need to figure out the schedule when Rhett starts school. And I'm also going to give you another $100 this month for school supplies. I don't want to miss any time with him, even if I do have to drive all the way to his school. I can get him there and pick him up all on time. I'll make sure of it.
Okay, and so in that text, you offered $100 for school supplies.
Yeah.
Okay, how often do you do that, to offer extra help with finances?
So I offer any of his sports. I offer to pay for any of it. I've offered, I always pay a little extra for school supplies. And I think this past year I did maybe I did a little more than 100 so that she could get him some more school clothes.
Okay, and you offered, but did you actually pay? Did you
Yeah.
actually give the money? Okay.
Yeah, I added on the check that I give her.
Okay. On the issue of the child support that was provided in the exhibit where Mrs. Maples texted you about that child support, what did you do after you received that text message? When she was giving you two options with regard to the modification of child support. And we can
Oh,
have the text
Yeah,
message.
that's when I had to start searching for a lawyer because I had hired Miss Kelly Jackson and I had paid $5,000 to get her, or what, I don't know the term that you call it, but
Mediation is what you're.
yeah, I
Okay.
tried to get mediation going, and first it was Miss Roberts' office had got COVID, and we had to cancel. That's what Kelly Jackson told me. That was what happened the very first time, and then I was going to. Now I'm not saying that you said that. She might have said that. I don't know. And then we had the second date scheduled, and I was literally on my way to that. And her assistant at the time called me and said that she was in a car wreck. And I was like, is she hurt? And she said, no, she's not hurt, but she can't make it today. And I was like, okay, so then there's that one miss. So that was twice that she canceled the mediation for me. And at that point, I had nothing had happened. I might have had $30 left in my little trust with her. And I just told her to keep it, and I didn't. I fired her.
Okay, and then so you got the text message asking you or giving you two options. Then after that, what did you do?
That's when I had to start searching for a lawyer.
Okay,
And honestly, it took me forever to find somebody because I tried multiple other ones, and there was a conflict of interest because the school system and her and her mother both work in the school system.
and then so the text message is dated May 20, and when did you get served with the modification for child support?
Is it June? I don't recall.
Possibly July. I think it was
Yeah, I was
probably
gonna say
July.
June or July. I'm not sure.
So you had about 30 days after the text
Yeah,
to getting served.
right.
Was it your intention to just not do anything with
No,
the
not at all.
modification of child support?
Not at all. I had to find a lawyer, especially one that I would trust. So it was quite a search.
Okay. Now, on the child support payments, when do you usually make the payment to Mrs.
I usually
Maples?
make the payment when I look at the calendar, I have a daily planner. I have one for every single year, and I even write down when I paid the check, and I look and I see it's usually the last time of the month that I'm gonna meet with her with rep for either be pickup or drop off.
Okay,
And that's usually when I give it to her.
okay, so in your recollection, were you paying it on time?
I mean, as far as work, yes, within the month, yes.
Okay.
I've never been behind a month, ever.
Okay. Are you agreeable to just doing a direct deposit? As
Absolutely.
was,
I would agree it'd be much easier,
for
much
direct
easier.
deposit? Okay,
I'm totally fine with that.
okay. Now, there was a testimony about daycare expense. Can you tell me about the issue on the daycare?
So the whole dispute on the daycare was we had put him in stepping stones. He was really little, and then it's in the parenting plan that I'm to pay all the daycare expenses, and I knew that, and I was paying it. And then she decided she wanted to move him to a better daycare. It was a way better daycare, but she had gave me the option and said I would pay is like $50 more a week, and she said I'll pay half of it if you'll pay the other half, and it's in a text, and I agreed to that. And she done it for about 2 months, and then it stopped.
Stop what?
She stopped giving me giving me that or paying that extra.
Okay. And then what happened did you somehow address that with the court or?
That was when she basically told me that she didn't have to pay it. She spoke with her lawyer and didn't have to pay that to me. And then if I wanted to disagree with it, to take it up with a lawyer.
And did you get a lawyer for
That's
that?
when I went to Kelly Jackson.
Your Honor, may I approach?
You may.
Thank you.
So that is the revised proposed parenting plan, is that right? And you're asking the court for a 50-50 parenting schedule?
Yes, ma'am.
Okay.
And if I can, just to make a statement, it's never been about the money. Like, I just want my son as much as I can get him. I don't mind paying her whatever I need to pay her.
Right.
Fair is fair. I agree with that.
I think there's a proposed parenting plan that's in the file.
It was filed, Judge, yes.
It's in the file.
Yeah. So do you believe that is in the best interest of your child to
I
be
really
able
do.
to spend an equal time between you and Mrs. Maples?
Yes, and I don't know where Rick gets it from. I know that could be hearsay. He knows days, and he asked me, why do I get 5 days with you and 9 with my mom?
Sustained.
You can't say what other people say.
Understood.
Okay, and in that proposed parenting plan, there was a provision where if you're not able to spend your parenting time, that your parents will have the first right of refusal. So we removed that from our revised proposed parenting plan, is that right?
Yes.
Because that's no longer applicable in your case.
Right,
You're married
right.
now. Okay. And then the provision with regards to forfeiture when you're 15 minutes late or something like that, are you requesting that that be removed from the original
Yes,
parenting plan?
we never have an issue with that.
So you all have, yeah, as was established, you have been communicating well, so
Right.
that should not be there anymore, is that right?
Yes.
Okay. That's all I have, Judge.
Roberts? All right, thank you. You may sit down. Anything further, Ms. Hendrickson? All right, then I'll hear you. Do you have any rebuttal, Roberts? I'll hear you an argument. When you make this argument specifically, I would request you to point to the evidence of a material change of circumstances.
Judge, the TCA 366-101A2C provides for a modification of residential schedule. The threshold is lower, the burden of proof is preponderance by the evidence, material change in circumstances that's affecting the child's best interest. It's not limited to unforeseeable circumstances as provided in Ambrister versus Ambrister. That's citation 414 Southwest 3rd, 685, Tennessee 2003. It's a Supreme Court case. In Ambrister versus Ambrister, Judge, the court basically summarized the analysis, in which I'm sure you know about the analysis for the residential schedule. Basically, in that case, it's 1 year later after the parenting plan was established. The father filed for a modification because he has a change in the work schedule. He's remarried. The wife got closer to the child. And because of the marriage, the father was able to spend more time with the child. The wife was very supportive of that. He had the willingness to participate more and share in the parenting responsibilities, and the child had gotten closer to the father. And the Supreme Court in Ambrister basically held that that was enough to allow for a 50-50 residential time, which promotes the legislature's intent that parents should have, as much as possible, the goal is to get closer to maximum participation in the child's life. I also attached to the filing Edwards v. Edwards. It's a recent case. It's a 2023 case from the Court of Appeals. That resembles a lot with our case. In that case, the parties deviated for 16 months. They adopted a 50-50 parenting plan, and it's pretty much the same as ours. Ours is about 22 months of Thursday to Tuesday. But I do believe that we have shown the material change in circumstances here. Number one, child is now 6 years old. He's attending school. He was only about 2.5 years old when the parenting plan was established. Father, because of the change in his schedule and his motivation and the intentionality aspect, he's able to spend time with the child and is intending and desiring to spend more time and participate and put in more participation in the parenting responsibilities, which he is able and capable. Testimony of the mother was that there's no issues with parenting skills. Her concern was more on how the child will adapt to the 7 days on, 7 days off, which is just 2 days shy of what they're currently practicing. Other changes are that the parties are now married. Mrs. Maples have a little baby. My client is also married to Kristen. We heard from her. She's very supportive. Mr. Jacob was not here, but we heard testimony that Mrs. Maples' husband, Jacob, he's also supportive of the co-parenting of the parties. Mr. Jones and Kristen, they are going to have a baby, so that will be another change there. Noah, the stepbrother, if I could say that, has a good, really close relationship with the child. And so, Judge, we believe that we put on enough proof here for a finding of material change in circumstances that affects Brett in a meaningful way. And if we look at the factors to consider, the best interest factors, we believe that it would be in the best interest of Brett to allow the father, just as the mother is enjoying him, to allow the father to have that equal opportunity, so to speak. There's just really no reason why both parents should enjoy the child 50-50 in this situation, because they have been working really well in co-parenting this child. Thank you, Judge.
Ms. Roberts?
Had the case you had before and this case, and then this Maples versus Jones case shows what the court has to deal with on a daily basis. But the fact is that the law dictates in this matter that the petitioner has to prove a significant material change in circumstances and that a modification, and the requested modification, is the best interest. I agree that 36.6.101 subsection A to C states that it's a lower threshold to change the residential schedule than it is to change the primary residential parent. But in doing that, the case law that counsel states, it says 2 factors are relevant considerations in determining whether there was a material change in circumstances for the purpose of modifying a residential schedule. Number 1, whether a change has occurred after the entry of the order sought to be modified, and 2, whether a change is one that affects the child's well-being in a meaningful way, citing Drucker versus Daly in that matter. And this is the case that counsel submitted with the court, the 2023 case. And again, Your Honor, there's just been no evidence submitted. What has been submitted is these parties get along, that they co-parent, and that the current schedule is consistent with the prior parenting plan. The prior parenting plan says the father gets every other weekend, all times that the parties agree, and he can get the child on Monday afternoons and Tuesday afternoons. That provision, at other times the parties agree, the parties have agreed that it is, because Rhett started school, and it was preschool when he started school, that a bigger block of time with the father was appropriate. Prior to the change, there is no evidence that these parties did not get along. They were together, they co-parented. He was involved in extracurricular activities. They modified the schedule. And so all they've done is been consistent with this parenting plan. There is no significant material change that would warrant a change in the schedule that they're absolutely doing, which we say is consistent. And that's why when we filed in July of 2024, we filed to modify the child support, and the child support is based on the number of days the child was with the mother, the number of days the child was with the father, the cost of health insurance, the cost of daycare if there is any. And then, of course, my client was about to have an afterborn child, and the incomes of the parties. My client was going to have an afterborn child. We attempted to resolve that. He refused to resolve it. So we've incurred attorney's fees. He then counterfiled at that point in time asking for a modification. But there's been no proof in the record as to a basis for that modification. To the contrary, there is no need for a modification because the parties have consistently worked together. The previous parenting plan, again, is consistent with what they have done. And there's no need to modify it other than to put it in the number of days that he has, which is effectively 10 days a month that he gets. They have joint decision-making, and that's the other point that we have to morph to, is we filed a petition for criminal contempt. So it's not joyful that we had to file a criminal contempt, but again, Your Honor is aware of the difference between criminal contempt and civil contempt, in the fact that a civil contempt, if the court will, is the offending party holds the keys to the jail cell. You can undo your behavior. But in a situation where he violated the parenting plan by allowing the child to be baptized without making a joint decision for his mother, and again, the Court of Appeals has stated that the court has to maintain neutrality in religious decisions. But the Court of Appeals has also said that the court has an obligation to uphold the sanctity of its ruling. These parties have joint decision-making in religious decisions. And again, if you look at it, Your Honor was well aware of that you can't read emotions in text message, and oftentimes the written word is different in interpretation. But my client receives a text message and said, I talked to our boy last night about baptism and he got baptized today. So he knew it the night before. He tried to justify it from the witness stand and says, oh no, it was just a sudden expression of faith. But again, baptism is a major integral part of a child's upbringing, and both parents had the right to make a joint decision on whether this 6-year-old understood what his profession of faith was about. Do I want Mr. Mr. Jones jailed for that? No, but it does need to be constituted for a contempt scenario, because he did not consciously make an effort to allow Mrs. Maples to be a part of the decision-making at all. And then she had ultimately the veto power, if you would. She could have made the decision if they could not agreed. And again, so the whole scenario is, Your Honors, these people get along. The child is having additional time with the father because the parties agreed, and that's consistent with the parenting plan. We attempted to resolve this matter by calculating the number of days. Mr. Maples, for whatever reason, refused to do it, and as a result, my client has incurred additional attorney's fees that we think that we're entitled to. We can submit an affidavit once this court rules on it, but what we're requesting is that the existing parenting schedule stay in effect. We have their 24 tax return. We're due a modification from the day that we ask for the modification, which was July 2nd of 2024. From July of 2024 through August, when my client had her second child, he would pay 2 months of based on just their 2024 income. Starting September 1st of 2024 until the end of July of 2025, based on his income, her income, the number of days with each parent, which his would be 120, Your Honor. Then what we would ask is that he be calculated with child support for that time. There will be no daycare expense during that time, and there would be no daycare for the July and August of 2024. But his cost of health insurance would be calculated into there. And then starting September 1st of 2025, he would be credited with an afterborn child. And so a new amount of support would be paid at that point in time. We're asking for judgment for that amount, and he be ordered to pay that immediately. And that we're asking for a wage assignment to go into effect in order for a record to be kept, or in the alternative, that the court set a due date. And if the parties, again, the only reason that through the Child Support Enforcement Agency that it's useful is that we can get a record of it for time in memoriam, and we don't have to go back and get bank records and show whether a payment was made and when it was. But again, I think a due date, and if he can do an automatic debit from his account into her account where it's due on the same date, certainly we don't have any objection to that. So she knows when she's going to depend on it, and she can pay that support. But we do think that there's 3 different time frames in which you should set child support. But again, the overall question is there's just been no proof to justify a 50-50. I disagree. The legislature did not pass a 50-50. The court is well aware that the court has to maximize the time with both parents is the statutory requirement, consistent with the child's best interest. All parties testified that Rhett is flourishing under the schedule, that he is having a great time when he's with his dad. He's having a great time with his mom. The new step parents are involved in the child's life. There is siblings on both sides. There's a step sibling, then there'll be a half sibling on that side. There is a step sibling and a half sibling on her side, a half sibling on her side. And again, it just works. And again, just the fact of the matter is that he doesn't even worry about doing this until we file for an increase in child support. Should be very telling to the court, is just that he doesn't want to do it. It's our calculations, we have said. His income for 2024 should be based on both of their 2024, starting in 2025. He is making some $73,000 a year, and my client is making approximately $20,000 a year. So we would just request that Your Honor use those and set the support accordingly.
Anything further, Ms. Hendrickson?
Well, the notion that my client was not interested in addressing the child support modification is a mischaracterization. He has paid $5,000 to her previous attorney to get a mediation schedule. And unfortunately, things did not. He testified to that. And so the notion that he was evading the calculation is a mischaracterization of the true events. In Edwards v. Edwards, the court did say there that because there was an established status quo for 16 months, which I argue that this is what's happening here, we have an established status quo, that's a material change in circumstances. But we would ask further for the court to consider that because both parents are fit, there's nothing wrong with their parenting skills, their relationships are great, there's really no justification why this child should be prevented from having equal time with his parents. There was no proof whatsoever, no rebuttal proof to show that Rhett will not be taken care of if he spent 7 days with the father. I understand the concern that there's going to be a period of adjustment, but we are talking about a 6-year-old child. So I believe that because he's well supported by everybody, including the spouses of the respective parties, that he will eventually adjust to the new arrangement. Father again testified that he's willing and able to put in more time if given the opportunity. And I believe that the court should give him some credit for that. And we should, I don't want to use the word reward because I don't want us to be seen as punishing Mrs. Maples for being gracious. But in Edwards, it says here, we're not punishing the mother. No one wants to punish any parent for being a good parent. She, the mother, has been an excellent parent to this child. However, because of the status quo that was going on, the court adopted the 50-50. And again, in Ambrister versus Ambrister, all the changes that I had pointed out earlier are the same changes that were present in Ambrister versus Ambrister, where the father was given 50-50 because he was able to show the court that not only the changes occurred, he was also willing and actually spent more time than he was doing. It's because of the wife, and I credit it to the wife really for Mr. Jones. The wife, Kristen, really support Mr. Jones, and it enabled him to share with more parenting responsibilities. And so we do believe and submit that it is in the best interest of Rhett to have equal time with both parents who both love him, both care for him, and want what's best for him. Thank you, Judge.
Well, the first and foremost question before the court is whether or not to find that there's been a material change of circumstances. And both counsel have referred to appellate court decisions that deal with that. There is a distinction in the law now that is drawn between a petition to modify a custody arrangement, in other words, to change the designation of the primary residential parent, and the change of a parenting plan or residential schedule that, as was pointed out, the state legislature's new law and the interpretation of our Supreme Court in the Armbruster case, which is the 414 Southwest 3rd 685 2013 decision of our Supreme Court. The court basically points out the fact that the state legislature and the interpretation of that new state statute is that there is a lower standard for a material change of circumstances. And then our appellate courts have basically opined that that is a very low, they use the word very low standard for a material change of circumstances, having to do with just the primary residence, about the parenting schedule rather than the primary residential parent status. And in the Edwards case that Ms. Hendrickson has cited, again, there are very similar facts in the fact that in that case, the parties had also deviated from the original final decree and parenting plans provision and given the father more time. And as a result of that, that was one of the bases for which the father sought the modification of the parenting plan and alleged it as a material change of circumstances. Under the process that I'm required to follow, I have to find, first, is there a material change of circumstances? The court finds the following as a material change. One, that there was an agreed modification between these parties that increased his time from every other weekend from Friday to Sunday to Tuesday, from Thursday to Tuesday morning. That was agreed upon between the parties. Ms. Roberts cites the language at such other times and places as the parties may agree provision of the parenting plan, but that's, in my opinion, not applicable here where they've agreed to do it. And they did it because they're both trying to work out the situation, and to her credit, Ms. Maples was doing exactly what this court also instructs people to do: be agreeable, try to let him have more time. And of the opinion that she should not be punished for having agreed to do that and tried to help him, but it does constitute a material change because that is different than what was before. If I didn't find that material change of circumstances, then you'd be stuck with every other weekend from Friday to Sunday as the language of the parenting plan, and I think it's in both of your best interests to make the changes necessary to that. Another material change is the remarriage of both the parties. Clearly, I think both parties have remarried. Ms. Maples has a child in her home now, and that's a sibling. That the child that's involved in this, Rhett, is that your son's name, Rhett? Rhett has a new sibling in his home there with Mrs. Maples. He's about to have another sibling in his home with his father, and already has a stepbrother, Noah. And I can tell you, stepbrothers and stepsisters can have a great relationship. They can have a terrible relationship, but they can have a great relationship. And I hope that will continue, and that's something to be encouraged, because Noah can be a positive influence on Rhett and helping him with soccer, as some people refer to it as football, but if you refer to it as soccer, and my children played soccer, my grandchildren play soccer. As a result of that, I think it's great that Noah is helping him with that. But that is also a material change of circumstance, and that change in home environment. And again, I compliment both of these parties for their lack of hostility and animosity that I see so often in these type of cases, and the fact that the fathers new wife has, Mr. Jones's new wife has come before the court, and I'm impressed with her that she is highly complimentary of Miss Maples and what a good parent she is and how cooperative she is. And I think that's something that you hope for in every one of these cases, but again, very, very rare, unfortunately, in the cases before me. So I'm happy that that is the case, but that is also a material change of circumstances. All of those things are, material changes. Then the question becomes whether that change constitutes a change that affects the child's welfare in a significant way. As I interpret the case law now and so forth, I'm required to then apply the statutory factors that are set forth in the 15 factors that are set forth in the custody arrangements. I have to get to them, so I don't have them modified. I don't have them in my memory, but those are in 366106. I have to look at all those factors. They include the strength, nature, and stability of the child's relationship with each parent. And this is, in my opinion, a good relationship that this child has with both his parents. I think he loves both of his parents and he wants to be, with both. Each parent's caregiver's past and potential for future performance of parenting responsibilities, including the willingness to ability of each of the parents to facilitate or encourage a close and continuing parent relationship. Clearly, I think both of them have performed their functions. This is not a case where Mr. Jones has failed to exercise visitation. The argument about the monetary support, that's what the calculation was, $204. And the fact that he didn't maybe pay it timely, we're going to fix that. But obviously, that's a very low amount of child support. And the argument about whether he could have supported or not, Mrs. Maples clearly has been supplying the majority of the needs of the child, because the $204, even though he has the child as often as he does, is not nearly enough to support the child. So that factor would favor her, but I don't have any indication that either of them has failed to attend a parenting education. I think both of them are willing to provide the child. Although again, Mr. Jones's contribution has been less than Mrs. Maples. The degree to which each parent's been a primary caregiver would be Miss Maples has been the primary caregiver, and I think that is clear from what has been proven. The love, affection, and emotional ties between the child and parent, and what I hear is that this child is well adjusted and doing well and has a loving relationship with both his parents. The emotional needs and developmental level of the child is 6 years of age, roughly 6 or 7. And as a result of that, I don't have anything before me about his developmental level other than that he's going into the 2nd grade. And so that's fairly typical of the child that age. Moral, physical, and emotional fitness of each parent. And both of these parents appear to be completely physically and mentally and emotionally fit. And I don't find any problems with that. The child's interaction, relationships with other siblings, relatives, etc., and that factor, as I've stated, it favors both of these parents. But Noah being an age that he is and being with the father in the father's household does tend to show that that's a relationship that is beneficial to Rhett. The importance of continuity in the life of the child and the length of time the child has lived in a stable, satisfactory environment. My concern, and I don't mind telling you this, things are going very, very well. And I think this is a compliment to both of you. The modification you agreed to has benefited this child. My concern is throwing a hand grenade into that situation and completely disrupting it by disrupting the child's life, especially during the school year. And that is a concern that I have. I think the child is doing well under the circumstances. But I also have to balance that with the fact that the child seems to also be doing well with the father, and that, finding a way to increase the father's time without completely disrupting, the child's stability is the thing that concerns this court. Character and behavior of any person who frequents or resides in the home. Don't have anything negative to say about Mrs. Maples' husband. Didn't hear from him, but obviously Mr. Jones's wife made a good impression with the court. I believe she's a very positive influence. The employment schedules of the parties don't really factor in, and so forth. Any other factor deemed relevant by the court, and clearly one of those factors would have to be the petition for contempt that has been filed. Obviously, it is a parent's decision to make with the child regarding the baptism of that child in the faith that, and you know, a lot of times I don't know what either of you have in the way of what your faith is, but oftentimes we get into it where one of you, one parent may have one faith and another parent may have a completely different faith, and then here we go, we get one of the children is baptized. 6 years of age is an extremely young age. If you determine that, and again, I'm not trying to get into the philosophical or religious debates about this situation, but if baptism is serving a purpose for remission of sins, then a 6-year-old is highly questionable as whether that would apply. In any event, it is a part of the parenting plan that all decisions regarding religious matters were to be made jointly. The fact that Mr. Jones texted her to say he talked to the child the night before, the child then in court, in church, asked him, according to his testimony, if he could be baptized. It's a difficult situation. The ideal thing would be when you talk to your son that night, call up his mother and say, here's this conversation we had. We're going to be at church tomorrow. There's a possibility that our son's going to want to be baptized. And, you know, what do you think about that? And you two discuss it. That was the way it should have happened. You didn't happen that way. And so I'm now asked to find you in violation of that court. I do find you in violation of that court order, but I do not find it to be willful, deliberate criminal contempt. But obviously, if that were to happen again after this discussion, then it would be much more obvious that it was an intentional violation. It's just finding somebody in contempt for letting their child be baptized is hardly something that I would, you know, want to do and want to have on my conscience, but I will do it if I have to. So anyway, that issue is what it is. So having considered all of those factors that the court finds, the court is of the opinion that the residential schedule that the parties agreed to during the school year that this child is involved in should remain as to what they agreed from Thursday afternoon after school until Tuesday morning when he returns the child to school. That will be the schedule from this point forward. I do find that to be appropriate modification. Second modification is that the summer visitation in the current plan provides only for 1 week, I believe it is, during June and 1 week during July. I'm modifying that so that the summer visitation will alternate weeks. That gives you some of what you're asking for, to alternate the weeks between the two of you, but it does it during a period that will not interfere with your child's education and the stability that I think the child needs during the school year. You of all people, I think, can recognize that. But it gives you more time with your child. Now, you know, that, in my opinion, is the best modification that I can grant that also recognizes the needs for this child's stability and the need for the father to be involved in the child's life. I am of the opinion, having made that, you're going to have to recalculate the number of days. And then I believe the proof has been pretty forthcoming. We have a court reporter here. So the proof that has been established in this court as to what the incomes are will be used to calculate the child support based on this new residential schedule. Pardon me. And I agree that the schedules will have to be in three separate, the calculation will have to be in three separate denominations because of the fact that there's a child now with her. He's expecting a child in his home, and once that happens, there will be a new modification, and then we'll have the days will be different. So I would expect Ms. Hendrickson and Ms. Roberts can come together to do that. If not, I'll see you again, but I'm of the opinion that my concern was greater trying to determine what to do in this case regarding the residential schedule than the actual dollar figures of calculation of child support, and hopefully we'll be able to get that done between you. I will say this again. Obviously, the medical insurance and all of those other issues will go into the factor. There's no work-related child care, if I understand it. Also, because of the fact that there's been some, at least, distinction, both of you have no spouses in your life. Let them help you with the children. If you need to, have somebody, if you need to have your wife pick up your child, let that happen. If you need to have your husband pick up the child, two of you, are now a family unit over here and a family unit over here. Let that child know that he's part of both of those families, and don't argue about who's going to pick up the child and so forth if there's any reason to do that. The modification about the first right of refusal, taking the grandparents out, that's clearly, obviously, no longer necessary because of the fact that Ms. Jones is now available and will be around to help with that, just like Mr. Maples will be as well. Is there anything I have not addressed? Well, in my opinion, I'm of the opinion that this is a matter that benefits the child, and therefore I decline to award attorney's fees to either party, only because of the fact that there is a need for a modification, as I've found. But then there's also a fact that he's not awarded any attorney's fees for this modification because of the fact that I find that there is a requirement of modification of the child support. So I decline to award attorney's fees in either event. So. I'm sorry? Hit your microphone, turn it on.
Sorry. Oh, there it is. The provision in the parenting plan that talks about forfeiture if someone's late 15 minutes and things of that nature, we requested.
Yeah, they're not meeting.
That provision is in there for halfway at some place, that somebody doesn't have to wait.
It would make the most sense that way because of the simple fact that that's what your schedules already is. So let's just do that.
What I did is Dixon County School is out on an average of 9 weeks in the summer. There's 52 weeks in the year. So if you take the 9 weeks off of that, that's 43 weeks. Every other week is 21.5 that he gets 5 days. So during the school year, he gets 107.5 days. Of the 9 weeks in the summer, that's 4.5 weeks that he would get 7 days. And that would be 31.5. So his day count is 139, hers is 226.
I'm going to take it that is correct unless Ms. Hendrickson finds some calculation to be an error, then that's what it'll be.
And again, like I said, I just took as an average, they're out 9 weeks. They divide those 9 weeks equally. And then again, the rest of the time, he gets 5 days for 21.5 weeks. And that's where I came up with.
All right. Now, what I said earlier applies. You two have been one of the most refreshing couples that I've had before me, in that you and Mr. Jones and his wife have all demonstrated the very attitude and spirit that I have tried to encourage in so many people, unfortunately, without a great deal of success. And I attribute that to partially to your nature, but also maybe your attorneys have given you good advice. I do not want to have this hearing today result in a deterioration of that relationship. I do not want to see that the two of you can no longer communicate because there's animosity or hurt feelings or something that was said in the courtroom. That's the danger that always is attendant to you coming before the court and litigating a case that could have been perhaps settled in mediation. In this particular case, I understand what happened. I understand why you had to bring it before me, and I don't blame Mr. Jones for wanting to be more involved in his son's life. And I certainly understand why, as a father myself, you would want to be there equally with the mother. But as a practical matter, I have a child that's already in a set schedule that I'm now trying to modify to give you more time without completely blowing up his life to where it's completely different. This is the best I can do. I'll probably lose sleep over it tonight, wondering whether or not your child is going to be okay as a result of this. I hope he will, and I hope the two of you don't have any problems between the two of you because of this hearing today. So let's try to see if we can't get this child support issue worked out by agreement. If not, you can revisit it with me just by setting it before the court. Anything else?
Did you want it by wage assignment, or did you want a direct deposit where you get it quicker? Okay, and we can do the direct deposit.
Yes, the direct
So
deposit will be the
I
simple.
just
I'm not
wanted
going to order wage assignment. I'm going to
Right.
order that you make it on a specific date, agree on a specific day you can make it, and make the deposit, wage deposit by that day.
Right, and once we do the numbers, we'll check and make sure whether he wants to do it according to his pay period or one time, and we'll just pick a date that it will be deposited by this date, and we can exchange that. I just had not asked my client whether or not she had a preference as to the wage assignment,
Right.
but I think a direct deposit gets her the money quicker, and you don't have to deal, I don't want the state touching my money if I don't have to.
All right. Mr. Jones, when my son got to be about 5 years old, and I was trying to find that my wife and I were trying to find something to enroll him in to burn off some of his energy that he had. I just found out they had a soccer group that was about that age. Anyway, I grew up in Houston County, Tennessee. I'd never seen a soccer game played in my whole life. You know what I did? I went to the library and I checked a book out about sports and different games and how, what the rules were for each one, and I read up on it. Then I bought another book about because I ended up having to coach him, and I didn't know enough about coaching him to do anything, but I ended up buying a book that gave all sorts of drills and, practice tips and things like that. So some of the best times of my life were, when I was coaching my son. Pickleball? Oh, I thought that was
That's an old
an
game.
old person's pickleball, I thought was for old people.
Yeah.
All right, well, I think you all are great folks, and I hope, like I say, that you take what I've said with everything, with the sincerity that I have intended it for. So good luck to all of you.
Thank you, Your Honor. You okay with that? All rise. Yeah, don't have a choice. But,